All right, I think we're ready to start our afternoon court calendar. And we'll do that by calling the case of the state of Wisconsin versus EREKA Mason. It's case 26 CM4. May we have appearances, please?
Cameron Davies for the state of Wisconsin.
EREKA Mason appears for this proceeding by video. I see.
Well, let's confirm that that's the case. Ms. Mason, can you hear us?
Yeah.
Okay, real good. I just can't quite see you on the video, but I did hear you reply. That's fine. Thank you.
I can finish.
Attorney Lencioni, yeah, back over to you for the introductory comments.
All right, so as stated, Ms. Mason appears by video for this proceeding. In the courtroom is Attorney Tracy Lencioni. This is a special appearance. I have received a copy of a criminal complaint that contains 2 misdemeanor charges. Ms. Mason, can you indicate by giving a thumbs up whether you have received a copy of the criminal complaint?
Yeah.
Okay, so we waive formal reading. It does appear as though the address at 615 East Wash is the proper mailing address for Ms. Mason, and she is eligible for public defender representation.
All right, thank you. And as noted in the complaint, she does have the open misdemeanor case in Sauk County. I don't think there's any open Dane County connection that would require assignment to any particular branch. So guess we'll let the computer pick what judge gets assigned to this for trial purposes. Does the state have a position regarding bail?
Yes, the state is going to be requesting $500 cash bail. The state would ask for non-monetary conditions that the defendant just be banned from UW Health East Madison Hospital unless brought by law enforcement or an ambulance for a legitimate medical emergency. The purpose of cash bail, there's obviously the bail jumping offense here that alone causes concern to the state. I would also note she does have a number of bench warrants from the past year. Looking at her Sauk County case, I'm seeing bench warrants from February of this past year. Didn't realize we were in 2026. February of this past year, 2025, that was out for a little over a month. Bench warrant from April of last year and a bench warrant from September of last year that was not served until just about Thanksgiving. So all told, the state does believe some amount of cash bail is appropriate to assure appearance.
All right, thank you. And Attorney Lencioni?
We would ask for a signature bond for Ms. Mason for this case. There is acknowledgement that there have been prior missed court appearances, but it was due to transportation issues, not for any sort of intention on Ms. Mason's part to not appear in court. She has resided in Wisconsin for the last 4 years. As stated previously, she uses the Beacon as her mailing address. She does have an 11-year-old child who does live with her, and she does receive disability benefits. So there would be a concern that should she remain in custody, that she would lose what appears to be at this point her sole source of income. And as previously stated as well, she does qualify for public defender representation. So in light of the fact that these are misdemeanor charges, nonviolent, I would ask for a signature bond despite the state's recitation of prior missed court appearances for Ms. Mason.
With the pending case and the rather substantial history of missed court appearances, as well as the fairly substantial number of recent convictions described in the complaint, at least 3 occurring within less than the last 2 months, I'll find that cash bail is necessary to assure her appearance in court. I'm also concerned about likelihood of following conditions given the pending Sauk County case and the statements attributed to her in the criminal complaint. I'd be willing to set it at an amount less than what the state proposed. I'll set it at $350. I'll have as conditions that she not be at the UW Health East Madison Hospital unless brought there by law enforcement or ambulance. And I'll also have as a condition that if that's the case, she must leave immediately upon discharge. I'll get a not guilty plea entered on Ms. Mason's behalf, and we'll get the case sent on to whoever the assigned judge is for further proceedings. Good luck, Ms. Mason. Take care.
Next is Mason Gunderson. Gunderson. We have a PSA version.
I don't see one, but let's find out from Ms. Anderson if there's one available.
No, there is not one for him.
Okay, thank you. Why don't we, if we didn't do it, let's call the case of the state versus Mason Gunderson, case 26 CF 11. Appearances, please.
Cameron Davies for the state of Wisconsin.
Mason Gunderson appears in person and with Attorney Joseph Kennedy. Good afternoon, Your Honor.
Good afternoon. You should have a copy of the criminal complaint.
We have a copy of the criminal complaint. I've reviewed it with Mr. Gunderson. He is aware of the charges. The address is correct. We would request a preliminary hearing be set, reserve argument about tolling time limits for that regarding counts 1 and 2. On count 3, I'd make a motion to dismiss with brief argument.
Okay, we can turn to that in just a moment. I do have a procedural question. The circumstances described in the complaint suggest that there would have been an earlier arrest with some cash bail posted. I just don't know if we have the information about whether that's the case and the amount. The clerk, I think, is checking for us.
I'm sure it appears there's $400 left filed from that arrest on the door.
Okay, thank you. Appreciate that. And yeah, and I'm sorry, go ahead, Mr. Kennedy.
And that's the amount. Mr. Gunderson is correct.
Okay. And I think you wanted to be heard regarding the sufficiency of one of the counts.
Sure. Count 3, the misdemeanor violating having contact after a 72-hour no contact order. If I'm looking at that section of the criminal complaint and what's relevant to that in the probable cause section, the only indication there is that Mr. Gunderson was having contact with the residents of initials AMK, not JAG, JAG being the one who would be subject to that 72-hour protection. This is a duplex property. However, everything that we see in the criminal complaint indicates there's only an attempt to have contact with AMK, AMK's residence. JAG is not indicated in the PC section to be present at that time. In fact, Mr. Gunderson took some actions that seemed contrary to try to violate that order. He contacted law enforcement himself while at the residence, trying to get back his property. And also the property that he was trying to retrieve, a key so that he could return to his own separate residence, was located in JAG's vehicle per the statements of AMK. If Mr. Gunderson were not trying to abide by that no contact order, certainly it would make more sense for him to go to that vehicle and get his property back rather than try to ask AMK to facilitate this. So for those reasons, understanding it is a low burden on a motion to dismiss, I am going to ask the court to consider a motion to dismiss based upon what's written in the probable cause here.
All right, I think I followed that, but I may come back to you for follow-up questions, just because the facts there were a little complicated. Of course, my analysis is going to have to be limited to the facts contained in the criminal complaint for the purposes of the motion to dismiss. Does the state have a response to that argument?
Sure. I mean, it seems like this is a duplex. 2 people live at it, one of which the defendant was under the 72-hour no contact provision to not contact. He's at the residence. I think that with reasonable inferences drawn in favor of the state, that's pretty clearly a violation of the 72-hour no contact.
Well, the complaint seems to describe it as either a shared driveway or Mr. Gunderson's vehicle being parked on JAG's portion of the driveway. I guess I don't know what the layout is exactly, but again, then I'm sort of stuck with what's described in the complaint to make the decision. Based on record evidence in the complaint, does either party have additional argument to make on that point? Well, on either the driveway point or the sufficiency of the complaint more generally? Obviously, this is the least serious of the charges in the complaint, but it's, if there's a basis to dismiss it, we should hear that.
Sure, again, any argument I would make would be outside the four corners of the complaint at this point, so beyond what can be argued for purposes of a motion to dismiss at this point.
Okay, and anything else from the state on that?
No, Your Honor.
Well, so the standard is that if somebody is subject to a 72-hour no contact prohibition, they're required to avoid the residence of the protected person. This complaint describes the location as being perhaps a residence on one side with a different residence for a different individual, also described in the complaint on the other side. But I think, so there's, I think, an argument that being on one side of the duplex isn't failing to avoid the residence. But I think more importantly, for the purposes of pleading, there's a description of Mr. Gunderson being parked in JAG's driveway, which is certainly not avoiding the residence if those facts are true. That doesn't necessarily mean it was an attempt to contact JAG. I think that's Mr. Kennedy's point. That's a separate provision of the 72-hour no contact prohibition. I think at this point, I'm obligated to deny the motion to dismiss. I do need to talk with everybody about bail. My understanding is that JAG may be present via Zoom and wants to add something about that. We should pause to give that person a chance to do that. So if you would like, there you go. I saw you unmute your microphone. That was good. What do you think we ought to know about bail or conditions of bail in this case?
I just wanted to express my concern about his release without supervision, just because I know that whether or not the no contact was being violated is up for question. But to me, he was immediately released and came straight to my house. And I don't believe another no contact is going to stop him from showing up at my house. He obviously has no regard for that. And I just want it to be clear how unsafe I feel. And I just feel like it would be better if there was some way he was monitored, just because I'm genuinely concerned about my safety based on his actions recently. And I don't know that I agree with bail being at what I was told it was going to be.
Well, there hasn't been a decision made about that yet. I'm still hearing input from both of the lawyers, and I can also hear input from you about that. So if there's something you wanted to add there, now's a good time.
I just feel like if the bail amount is low enough and he's out without monitoring, I have no doubt in my mind that he's going to show up at my house.
All right, thank you. And the state's position on bail?
Yes, Your Honor. The state is going to be requesting $2,500 cash bail as for non-monetary conditions that the defendant first have no contact with Jade G, and that the defendant have no contact with Anthony K. Would ask that the defendant be banned from the 6600 block of Birch Drive in Windsor. I would also ask that the defendant be subject upon release to pretrial services to enforce that geographic ban. Would ask for conditions that the defendant not use or possess any dangerous weapons, as that term is defined by statute. That the defendant not be in any residence where firearms are present. That the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription. I think that the statements made by Jade are appropriate for today's purpose. I'll supplement them by noting just a few facts from the criminal complaint that raise concern for the state. There's obviously the violation of a 72-hour no contact, the fact that it was violated pretty much immediately by the defendant, that when he had contact with law enforcement, he engaged in fleeing behavior. He then engaged in hours of standoff with police, took canines, drones, a crisis negotiation team, even after the defendant discharged a firearm in his home, a tactical response team. It looks like during the half-mile pursuit with the fleeing, the defendant reached speeds of 80 miles an hour. All told, between the behavior when in contact with law enforcement and the immediate violation of a no contact provision, the state does believe that there's a substantial risk the defendant will not abide by conditions of bail, and that cash bail and pretrial services are appropriate to ensure that he does.
And as noted by Mr. Kennedy earlier, there's not a pretrial assessment in this case. Do you have information about prior criminal record or other relevant history?
In terms of failures to appear, I can see in my notes that the defendant doesn't have any. That matches up with what I saw previously. Taking a look at prior criminal record, I am not seeing anything of note in Dane County. I am seeing one conviction from 2013 out of Milwaukee. And then I just would note that there is the sort of underlying case for that 72-hour no contact. My understanding is that has been charged out by our office, although it hasn't formally been filed at this time.
Is the 2013 case from Milwaukee, or is it Dane County case 13 CM 2781?
Give me one moment. My notes look like 2013 CM 2781, and given this is coming from our internal system and not CCAP may be more accurate. That seems to have been a deferred prosecution agreement, so the charge was ultimately dismissed. I'm looking at 2013 CM 870 out of Milwaukee.
And I'm looking at what's publicly available on CCAP and see no convictions for Mr. Gunderson.
Okay, thank you. In the Milwaukee case was 13 CM 871?
870. 13 CM 870. That may be mislabeled in my system as a criminal charge. Looking a little further, that may have been a forfeiture. But because it seems to have conflicting information in my office, I won't represent one way or another.
I think I can view it in my computer. Let me just take a look at it and I can help clarify it perhaps. The Milwaukee County case 13 CM 870 looks like it was originally charged as a misdemeanor obstruction. It was resolved with a violation for disorderly conduct under section 63.01, which almost has to be a Milwaukee County ordinance violation of some sort. Also potentially relevant, though certainly dated, is Dane County case 13 CM 2781. That was the deferred prosecution that the state referred to earlier. Because I viewed it, I think it's only fair that the defense have the opportunity to view a copy of the criminal complaint from that case. It is not irrelevant. Does the state want a copy of that too?
I should be able to have that. If I don't, I'll raise that issue with the court.
Sure, we're just making a copy here for Mr. Kennedy.
Yep, I've had a chance to review it.
Okay, real good. And Mr. Kennedy, your argument?
For arguing, I'll start with the things that we're in agreement with. I have no objection to the no contact orders that were the no contact orders with the geographic location, no contact orders with the two individuals. I would ask for the court at this time to make an exception if there is a specific order in Dane County case 2024 FA 2116 that any compliance or any contact permitted by those orders would then be exceptions to this no contact bond condition. That case that I just referenced, Your Honor, is the party's divorce case. There was a divorce action that was filed in the middle of last month. With regards to the statements by G, I can think of some things off the top of my head that would very clearly cause the parties not to need to have contact, or for Mr. Gunderson not to need to have contact. That's if keys to his own separate residence are not located in her vehicle, and if the parties have court orders and decisions made regarding the possession of shared animals. Thankfully, they don't have minor children in common. That's going to cut down on a lot of that, but they do need to disentangle their personal lives and their personal marital property and their community property. So I would ask for those exceptions in relation to that. Commenting on the conditions in or the criminal complaint in this case, again, part of my reason for bringing the court's attention to the questionable facts regarding the violation of the no contact order, even though I fully expected my motion to be denied, was to bring up that the reason that this has initiated with police contact is Mr. Gunderson, following an arrest, needs to get a key so that he can get back into his own home. That's why he's there. That's why he's initiated contact with police. When he believes he's free to leave and the police have indicated, no, this is a violation, that's what starts the process of him leaving and returning to his residence once he has his key. Yes, there was a standoff that required police to take some additional measures to get Mr. Gunderson to leave his residence. I would note that at the outset before Mr. Gunderson did not care to leave his residence, in the state's own criminal complaint, I see where they say Sergeant Colebrook unholstered his service pistol and pointed it at the defendant through the window. So while Mr. Gunderson is inside his own home, he has law enforcement that's pointing firearms at him. I think contextually that's relevant for then why he was not acquiescing to their request that he come out of their residence. That, with a fairly limited to no prior record, he has long-term community ties in this community. He owns and operates an American Family Insurance Agency out of Beaver Dam. I believe he is able to comply with bond conditions that are going to be set forth with much more clarity from the court here, and will not be a risk to violate or to not show up to court, which are the court's primary concerns in setting the conditions of bond and the bond itself. I don't believe there's a need for pretrial services to be monitoring, i.e. for him to have any sort of a GPS monitor with these bond conditions being clearly set forth at this time. If the court disagrees, I would ask that that not delay his release further. He's already been held in custody since December 30th at this point. So if he is required to comply with pretrial services, I would ask that he be permitted to return to the courthouse, no later than 10 a.m. Monday morning to fit that bond condition if the court deems that necessary. Lastly, in terms of the bond conditions, the cash bond, I don't believe a cash bond is appropriate in this case. I believe a high signature bond would have an appropriate effect. If cash is required, I don't think $2,500 is a necessary amount. I would ask for a smaller amount. I think $1,000 is appropriate here.
Any response from the state?
Sure, I'll keep it brief. I'll note that I understand family court proceedings and things like that can be complicated. I don't think the way to respond to them is by immediately violating 72-hour no contact. I've received information while we've been speaking from the charging attorney that apparently the defendant had contacted law enforcement to effectively, perhaps not legally, but effectively get a preserve the peace. He wasn't willing to wait for them to show up, and that led to this situation. When law enforcement arrived, rather than work with them, he fled them. Rather than work with them over the course of 3 hours in a standoff, he discharged a firearm. He continued to hide. He threw a blanket over a drone. I think that behavior makes me extremely concerned about what could come next if he is released without these conditions. I certainly think pretrial services at a minimum as a condition of release is appropriate, given the fact that, again, he wasn't patient the day of, and it doesn't seem like he has much regret for this type of behavior. So I think both the cash bail and the pretrial services are appropriate.
All right. Well, I have had an opportunity to review the allegations in the criminal complaint. We've talked at some length about the prior involvement with the criminal justice system, which in some respects is minimal to the extent that there was a deferred prosecution resulting in dismissal in the Dane County action, and then a conviction for a non-criminal ordinance violation in the Milwaukee County case. In my analysis, I really don't put much, if any, really weight on the Milwaukee County matter because it was ultimately resolved as a county ordinance violation, it appears, and it's dated. I do put some weight on the prior Dane County case because it's an allegation of a threat to arm himself and hurt somebody with a gun. He would have entered either a no contest or guilty plea to that charge in order to go through the deferred prosecution agreement. Ultimately, he successfully completed that, results in no conviction, but it's concerning behavior because it suggests a lack of isolation in the sort of behavior that's described, or that's not isolated behavior. In fact, the complaint I have in front of me says that the arrest that occurred for the offense that led to the 72-hour no contact prohibition was based on an incident about a month prior where there was discussion of arming himself with a firearm, unsuccessful efforts by law enforcement to have him taken into custody, and a decision made in November to what the complaint terms as disengage with the defendant, end quote, by law enforcement. And then we have what's alleged in this complaint. I can respect the point that perhaps his intention in going there was to try to retrieve property, but I think the state's spot on. The whole point of a 72-hour no contact prohibition is that there has to be the involvement and intervention of law enforcement to get that to occur within that 72-hour no contact period. What's described in the complaint is the antithesis of cooperation with law enforcement. There's a description of a admittedly short vehicle pursuit, frankly, despite the deployment of a rat trap on the vehicle, though I don't know whether Mr. Gunderson would have known that that had been deployed on the vehicle. There is a shot fired during a rather lengthy standoff. Ironically, perhaps, I don't think any of the 3 counts in this criminal complaint are Act 3 offenses. That's kind of surprising to me, but unless I'll stand corrected if somebody can point to something different, I don't think any of those 3 charges fall within Act 3, which means I have to make a bail decision based on likelihood of appearance in court. Still there too, there's extreme risks in terms of the likelihood of appearance in court. As the state terms it, the complaint suggests that Mr. Gunderson wasn't willing to wait 10, 15 minutes, maybe an hour for law enforcement to come before allegedly engaging in the behaviors in this complaint. I also realize that while I wouldn't set cash bail solely for community protection reasons, because it's not an Act 3 eligible offense, I don't think I should ignore them in terms of setting the conditions of bail or taking a look at what a bail amount ought to be. I view this case, I think, a little bit differently than both of the parties involved, and much more consistently with what JAG described during her statements. There are reasons to be gravely concerned about the likelihood of Mr. Gunderson appearing in court if released on a signature bond or some sort of a minimal cash bail. There are strong reasons to be concerned about the likelihood of, and I don't mean to differentiate grave from strong in this context, the risks are very high. Mr. Gunderson is somebody who does not have a substantial prior criminal history, and that's to his credit. That's something I have to factor in here. I also factor in the fact that it appears to be a series of crisis moments, perhaps, and that it doesn't necessarily define who Mr. Gunderson is as a human being, or suggest that he can't do better in the future or avoid this sort of situation. But when I look at what the alleged response was to the presence of law enforcement, that if I'm understanding things, he called, I don't see any of these bail results that are described by the parties as being sufficient to meet the risk. I'm not willing to set cash bail on this at any number less than $15,000. I'll set that. I'll order as a condition that he's not to be released from the jail until pretrial services has outfitted him with a GPS device. That's going to include GPS monitoring of him not being, I'm gonna call it on Birch Drive in. Well, and I want to make sure that's the correct location. Is it Birch Drive that the state seeks to have him?
That is what my notes indicate.
Well, and I ask that only because the initial call looks like it was to Depot Street.
No, the residence Mr. Gunderson is residing at separately is the Depot Street. The address
Okay.
of the 6638 is, or correspondingly, whichever other duplex number that is, that's the address where Miss Gunderson resides.
And that's the place that he would need to be banned from, and would need to be monitored. So we'll call Birch Street as it actually, I think, is Birch Drive as the location that he's not to be. He's not to go armed with dangerous weapons, and not to be in any residence where firearms are kept or stored. We'll get it scheduled for a timely preliminary hearing, as I assume that's his request.
Yes.
Okay, we'll get that done. You know, Mr. Gunderson, this is the very beginning of this. This isn't the end of it. You're gonna have an opportunity to have bail reviewed going forward. Perhaps some sort of a plan can get put together better than the ones I've heard here today. I do hope things improve for you. I'm glad that this resolved ultimately with you coming out. That's a heck of a lot better than some of the alternatives. But I can't not be concerned about what some of those alternatives could have been and what they might be in the future. And that's why we're doing what we're doing here today. You're all set, Mr. Gunderson. You're good for today, and I do wish you well, and the same for you, ma'am.
I'm not sure if you actually said all of this, you know.
I did intend to order that he not have contact with two individuals identified by the state. I'm going to decline to order the drug-related condition because that violates the law anyway, so it doesn't need a specific condition.
The exception that I asked for with respect to explicit family court orders, Your Honor.
Right, so I'm not going to provide an exception for contact to like exchange property or something like that. It is, and I'll say this on the record for everybody's purposes, I don't think it's a violation of anything for Mr. Gunderson to like show up at a court hearing or for scheduled court proceedings, or to have contact with her via an attorney or law enforcement. You're all set, Mr. Gunderson.
Waiting for a prelim date. Right now, I'm looking at January 13th at 1:30. The day is pretty wide open if you need a different time.
We do sometime that morning.
Yes, January 13th, 9:30.
That'll work.
Next is Andrea Smith with Zoom. And Bill, I think that we might actually have an interpreter logged in for Mr. Singh. What did he say? I can't hear.
Yes, Your Honor. Interpreter for Mr. Amar Singh.
There are two different
Okay.
things after this one.
Thank you for being here. I think that's going to be not this very next case, but the case after.
Thank you, Your Honor.
Any of us were aware that Mr. Singh needed an interpreter this afternoon, nor that one had been arranged, so it'll.
Sounds fortuitous. Why don't we call the case of the state versus Andrea Smith? It's case 25 CM 2822. Appearances, please.
Cameron Davies for the state of Wisconsin.
Ms. Andrea Smith appears for this proceeding from the Dane County Jail. In the courtroom is Attorney Tracy Lencioni from the Public Defender's Office. Ms. Smith, could you please give a thumbs up about whether you can hear what we're saying in the courtroom? And then also, did you get a copy of the criminal complaint that has the misdemeanor charges?
I see the thumbs up.
Thumbs up? All right.
And just to clarify, I think we're here on return of a bench warrant issued after a missed pretrial on December 19th. So
Okay,
she would have,
thank you.
she may have received another copy of the complaint today, but she would have also received it at the initial appearance.
Thank you.
Any information about the missed court appearance, Attorney Lencioni?
No, I do not have any information. What's the date again of the?
December 19th?
Okay. No, I do not have any information about the missed court appearance on the 19th.
Okay, and You want me to ask her? Ms. Smith, I'm sure Attorney Lencioni doesn't want you to talk about the allegations in the complaint or any of that, but if there's any good information we should know about why you missed court, I'd certainly want to hear that.
Somebody gave me a different date, so I got the date mixed up, that's all. My case manager told me, she's the one that gets all my mail and stuff, so she told me it was a different date, and she realized that it was the 19th until, that's why I called the police and turned myself in the other night.
Okay, and is the Olin Avenue address the best one for us to use for you still?
Yes, it's she just had a lot of, she just got a lot of clients that she deals with. So she got I'm not the only one that I'm the one that's in jail. One of her another couple of clients are in jail too. So she got the dates mixed up, so, but we'll be on top of it next time.
All right, what's the state's position on bail?
I think I don't have any information to contradict the fact that Ms. Smith is saying she turned herself in. There's concerning history. There's a failure to appear a little over 2 years old, as well as this most recent one. There's a history of resistive behaviors and convictions, but without any information to dispute that, and given that this is the only failure to appear in the past 2 calendar years, I'll stipulate to reimposing a signature bond.
And Attorney Lencioni, any additional information you'd add?
No.
Well, I guess I'd like to know a little bit more about the turning oneself in part of this. What did that look like? Did you go to the police department or call? I think you said you called.
I had somebody call the police and told them I have a warrant, and I was out in the freezing cold, so I'd rather been in jail than out. I'm sick right now. I'm really sick, so it's not even funny. So I just got tired, cause I'm homeless. So
Okay. So that was not correct when you said you called the police to turn yourself in?
what I can't hear him. What'd you say, sir?
Yeah, I said, so it was not correct information when you said that you called the police?
It was. I had somebody call the police and tell them I had a warrant out for my arrest and I have to turn myself in.
Oh, you asked the other person to call in?
Yes,
Okay,
but I don't have a phone.
thank you. Anything else from either of the lawyers?
I don't have anything to add.
No, Commissioner.
Okay. She's listed on the booking sheet as having been arrested at 2417 Vondran Road. And I think that is in the general neighborhood of an area where sometimes people who don't have housing stay. Obviously, it's been exceedingly cold the last few days, and I recognize that as well. I'll go along with what I understand to be a joint request to reinstate the prior signature bond. Ms. Smith, I did hear what you said about maybe being given some incorrect information from a caseworker, and I'm not questioning you about that. That may well be true. I'll just remind you, I guess, that it's really your responsibility to know your court dates and get there, because not trying to rub your nose in it, but obviously you're the one that winds up sitting there if you don't, and
Right,
I don't want that to happen.
Exactly.
Yeah. Okay. And well, we'll get you some paperwork here, and we'll hope for the best going forward. I hope things improve.
They're gonna say this back?
Yes, ma'am. You're all set.
Okay, thank you.
You're welcome.
Next is Michael Pisano. Yeah.
I'm from the public defender's office. We're just here about bail, okay?
All right, we'll call the cases of the state versus Michael Pisano, cases 25 CF 1766, 25 CF 2429, and 26 CF 4. Appearances, please.
Cameron Davies for the state of Wisconsin.
Mr. Michael Pisano is present in court with Attorney Tracy Lencioni. This is a special appearance. We're here for an initial appearance on one matter, correct?
Technically, I think it's an initial appearance on 2. I think it's in
Two cases.
2429 and in 26 CF 4.
Okay,
And yeah, and right, so we're here on return of a bench warrant in case 25 CF 1766. There was a missed I think it was a prelim related status conference on December 22nd. And then in case 25 CM 2429, there was a missed initial appearance on the same date and time, or at least on the same date. And then we do have the fresh new case, 26 CF 4. We should get the two newer cases assigned to Judge McNamara because he's assigned to the older case. Let me just check one other thing here, because I think I saw that there had been a request by Attorney Anderson for a bail hearing. It looks like Mr. Pisano got picked up on the new charges and the warrants before that came to be, but let me just confirm that real quick. I think that's correct. At any rate, maybe the state has a position regarding bail on these matters.
Yes. In each of the new cases, the state is going to be requesting $500 cash bail. In case 26 CF4, I will request non-monetary. You know what? I'll make it the same non-monetary conditions for both cases. Those being that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription. I'm also going to ask that he not operate a motor vehicle. It's a little complicated making specific requests in cases involving controlled substances and not alcohol. But I think from the state's perspective, I'll just ask that he not operate a motor vehicle given the behavior in those two cases. As for the older matter, 25 CF 1766, I'll ask for $500 there. Two, in support of the cash bail requests, there's obviously the fact that he's now on 3 open felony cases here in Dane County. I'm seeing missed court appearances, or at least bench warrants being issued from May 9th of 2025. That was out of Columbia County, as well as May 19th and December 22nd of 2025 from Dane County, that most recent one being the reason we're here today. He also has referrals, I believe, out of Columbia County that I was able to see for failure to report to jail. Those ultimately weren't charged out, but certainly sort of raised the hairs on the back of my neck. There's the violations of conditions of bail involving these new cases. I think all told, there's a lot of smoke here and some amount of cash bail is required across all 3 cases.
I certainly can't speak to uncharged referrals in other counties, but it does look like he has a failure to report to jail case and a carrying concealed knife / felony bail jumping case pending in Columbia County. Attorney Lencioni, the defense position.
I did just want to finish, I think, I don't know that I finished the introductory remarks, that we have the.
Sorry about that.
It's okay, it's fine. But I just wanted to say that we have the complaints. We waived their reading. Mr. Pisano is eligible for a public defender, and in that regard, his assigned attorney, at least for the older 2025 matter, had informed me that with a missed court date on December 22nd of this year, which is, I believe, one of the court dates that the state cited as being missed, it was set for 8:30, but according to Mr. Pisano's public defender, Mr. Pisano reached out to his public defender at 1:30 that same day and had taken the steps to reach out to the assigned ADA about whether there was any objection to quashing the warrant that had been issued for the missed court appearance earlier in the day. The assigned ADA at that time did not object, and Mr. Pisano's public defender did file a letter that did not, I guess, get accepted into the record or removed from the queue or whatever the lingo is until today. But efforts were made prior to today by Mr. Pisano's assigned attorney. As far as other relevant information, it does appear that Mr. Pisano uses the job center as his mailing address. He's resided in Dane County for a substantial amount of time, for the last 27 years, having relocated here from somewhere that's a little south of us. He has a child who lives in the area as well as friends. And up until a short period of time ago, he was employed at a local company in Dane County. He has qualified for public defender representation now on all of these pending matters in Dane County. And Mr. Pisano also had informed me that he had been in a car collision the day prior to his missed court date. So that could potentially explain the miss, but then Mr. Pisano, being aware of the fact that he had missed court immediately or as soon as possible, reached out to his assigned attorney, who took steps to try to take care of those warrants.
Were you nervous to say Illinois?
What?
You talked about a state just a little bit.
Tennessee.
that's a little south,
State,
but-
little south.
But after 27 years, I don't think that's a problem. All right. And anything else from the state?
I won't amend my request, but I will say that I was looking through the information available to me, and what defense counsel represented is correct. It does look like a letter was filed December 23rd. It didn't make it into our system until today. And it does indicate that the state did not object to quashing that last warrant.
Okay, give me a second to just take a little bit closer look at this. Well, I'm struggling a little bit with how best to structure this and what the right answer is, because I have a fair amount of sympathy for both sides in some ways here. Mr. Pisano does have 5 open felony cases at this point. I don't know that that puts me in a position where I can really order a signature bond at this point. Legally, I'm sure I can, but I mean, the point is that I don't know that's an appropriate thing to do. I also am concerned about the fact that there is some failure to appear history, just setting aside the most recent one here that we're talking about. And he has a pending failure to report the jail case in another county. That's not significant from a bail risk perspective either. I do think he took some steps to try to deal with the missed court appearance in the 2 cases that are, I guess, the 2 older of the cases that are in front of us here today. I don't have a good explanation for why there would have been such a significant delay between the agreement filed to have those warrants lifted and them not getting executed. Obviously, it's the holiday season and that results in some delays, but that still seems like it's quite a long time. And so if this had gone according to plan, I suppose he would have not had those outstanding warrants. Doesn't really change the fact that he then gets arrested for new behavior, though I understand that it's possessory drug type behavior, not something more serious than that. I think we're at the point where I gotta set some cash bail. I'm not of a mind that I probably ought to set signature bonds in the cases where he missed court actually 2 times in a row. And then cash bail only in the newer of the cases. I think what I'm gonna do is set some cash bail across the 3 cases, set them in each case in amounts a fair amount lower than what the state proposed, so that the aggregate total is still hopefully not too bad. I'll set cash bail in each case. I don't mean to just split things down the middle, but I'm I happen to think the right number is about $250 on each of the cases. I'll set the bail at those numbers in. I'm gonna decline to order the drug-related conditions of bond in these cases simply because that's against the law anyway, so it's actionable behavior on the part of the state if there's a violation, and I think that's kind of shown by the existence of the new charges. In 2429, I am gonna order the no driving condition. I don't think that's really pertinent to 1766, and I don't know that it really would apply so much to the newest case either, case 26 CF4. So I'll not set that condition in those cases. Let's get not guilty pleas entered on any misdemeanor charges. I assume we should put on prelims right away on the felony charges that still need them.
Do you want your preliminary hearing? 20 days of today? Okay, we will not waive time limit.
Okay. We'll get those scheduled right away. I think that means that they would have to be held within the next 20 days. Yeah, Mr. Pisano, I wish the warrants had been lifted on a timely basis. But I also wish there hadn't been picked up on new charges here. But that's in the past. We can move forward from here, and I hope things work out for you.
Thank you.
You're welcome. Take care.
Next is Amar Singh, here via Zoom.
All right, I think we're ready to call the cases of the state of Wisconsin versus Amar Singh. They are cases 26 CF 2700 and 26 CM 6.
अमर सिंह जी का केस हम बुलाएंगे 2 नंबर दिए हैं दोनों केसों के
It looks like we have interpreter. Is your first name pronounced Bakar?
भास्कर your honor
Oscar, sorry about that. Also last name Singh, S-I-N-G-H. And Mr. Interpreter, do you swear or affirm that you will truthfully and accurately interpret the proceedings?
I do.
Okay, thank you very much.
Thank you. Your honor, bailiff's microphone is off.
I'm sorry, whose microphone?
The bailiff's microphone.
Yes. And that's a good point. Maybe now he's unmuted. Maybe we should have you just confirm that he's able to hear you and hear your words.
अमर सिंह जी आप सुन रहे हैं मेरी आवाज? Yes, yes.
Okay, thank you for checking that. May we have appearances, please?
यहाँ पे कौन है?
Cameron Davies for the state of Wisconsin.
Cameron Davis government के लिए है.
On behalf of the defendant Amar Singh, attorney Niels Weisnick.
Niels Weisnick अमर सिंह जी के लिए है यहाँ पे.
My appearance is on file in 25 CF 2700.
पहले केस में है आपके लिए.
I'm making a special appearance in 26 CM 006.
और दूसरे केस के लिए भी ये आपके लिए बताएंगे बोलेंगे.
All right, thank you. It looks like we're here on return of a bench warrant
हम लोग यहाँ पर
issued
वापस आ गए हैं बेंच वारंट के लिए.
and I just realized that I was starting to say the incorrect thing. We're actually here in case 2700 for a bail hearing because the new arrest triggered a violation report.
हम लोग 2700 केस के लिए हैं बेंच बेल के लिए चूंकि ये फिर से जेल में आ गए हैं वायलेशन के लिए.
Mr. Singh is a pretrial services program participant, and it's common for there to be a second look at bail when there are new charges.
आज ये प्रीट्रायल सर्विसेज में काम कर रहे हैं उनके साथ, लेकिन अगर कोई और गलत काम किया है तो फिर से इनके केस पे देखा जाएगा.
That case is assigned to Judge White, so we should also assign the new judge or the new case to the same judge.
जज वाइट के नाम पे ये केस है तो यह नया जिनका केस है वो भी जज वाइट को दिया जाएगा.
And lurking in the background is also a pending misdemeanor case assigned to Judge White. That's the case that forms the basis for count 2 in the new complaint.
और पीछे बात के देखेंगे तो एक और भी केस है मिस्टरमिनियर का जज वाइट के लिए, तो इसलिए नया केस उन्हीं को दिया जाएगा।
Does the state have a position regarding bail in these cases?
गवर्नमेंट कुछ कह रही है बेल के बारे में इस केस में?
Yes, Your Honor. In the newer case, the state will be requesting $300 cash bail.
हाँ, जो नया केस है उसमें हम लोग $300 कैश पैसा मांगेंगे।
I would ask for the sole non-monetary condition in that case that the defendant be banned from the shelter on the 2000 block of Zaire Road.
इसमें पैसे के अलावा ये कहना चाहते हैं कि ये शेल्टर पर नहीं जाए, 2000 जाई रोड पे है जो।
In the older matter, 25 CF 2700, I would also ask for $300 cash bail.
और पिछले केस में भी $300 कैश मांगते हैं।
In support, I would note that the defendant is now on 3 open cases in Dane County.
मैं ये कहना चाहता हूँ इनके पास 3 केस खुले हुए हैं।
He has prior bench warrants issued from January, April, June, and July of 2025.
इनके पास और बेंच वारंट है जनवरी, जून, जुलाई और मई में।
And is clearly unable to abide by conditions of pretrial supervision.
और जो प्री ट्रायल सुपरविजन की जो कुछ बातें हैं वो ये ठीक से नहीं कर पा रहे हैं।
So I do think cash bail in both cases is appropriate.
मैं समझता हूँ कैश बेल दोनों केसों में ठीक होगा।
It appears that bail had been $500 in the felony case prior to the opportunity at pretrial services.
तो पहले तो $500 बेल उस केस में हो गया था।
Mr. Weissman.
Thank you, Judge. Your Honor, I would ask that the court consider signature bonds in both cases.
मैं चाहता हूँ कि कोर्ट खाली इनका सिग्नेचर बॉन्ड दोनों केस में लगा दे।
I realize my client has some history of missed court dates. However, he also has a history of appearing in court and addressing prior cases.
इनके पास कुछ कई बार ये वापस नहीं आए हैं अदालत में, लेकिन और कुछ बार तो आ गए हैं अपनी बातों के कारण।
My client was just recently converted to a signature bond in 25 CF 2700.
2700 में इनको सिग्नेचर बॉन्ड मिल गया था अभी कुछ दिन पहले।
And aside from the bail jumping charge that's been filed in 26 CM 006, as well as the disorderly conduct in that complaint, my client had been showing some compliance with the pretrial services.
तो बेल जंपिंग की बात जो हुई थी उसके अलावा तो ये ठीक से और सारे काम कर रहे थे।
I'll note that there was violation reports addressing failure to charge the GPS device.
इन्होंने अपनी GPS को नहीं चार्ज किया था।
However, it's my understanding that my client was maintaining contact with pretrial services to address the instances of failing to charge the device.
लेकिन जो नहीं चार्ज कर पाए थे तो उनके बारे में प्रीट्रायल सर्विसेज ये काम करते रहते थे।
I'm not going to be dismissive of the misdemeanor conduct filed in 26 CM 006. However, the charges are misdemeanors. They are not felonies. My client is indigent. I would ask that if cash bail is going to be imposed, that it be no more than $100.
इनके पास कुछ पैसा नहीं है तो $100 से ज्यादा इनको लगा कुछ नहीं दीजिएगा, और खाली जो कुछ ने गलत काम किया है वो मिस्डीमेनर है, उन्होंने कोई क्राइम नहीं किया था।
And in 25 CF 2700, if the court feels inclined to impose a cash bail, and that I would also ask that it be in the amount of $100. I believe that it is commensurate with my client's significant lack of financial resources.
दूसरे केस में भी मैं चाहता हूँ कि खाली इनको $100 दिए जाए क्योंकि इनके पास कुछ पैसा नहीं है।
My client is not a flight risk. He is unhoused, has very little resources, and is essentially stuck in Madison.
के पास कोई घर नहीं है और कहीं और जा नहीं सकते हैं, मैडिसन में ही इनको रहना पड़ेगा।
Any response from the state?
गवर्नमेंट को कुछ कहना है?
No, Your Honor.
नहीं.
Well, the defendant now has 3 pending cases.
इनके पास अब 3 केस आ गए हैं.
All, well, 2 of the 3 are assaultive in some fashion.
और 2 किसी तरह के कुछ उन्होंने असॉल्ट किए हैं.
The third is not assaultive, though it's sort of an allegation of pointless damage to property.
30 असॉल्ट नहीं है लेकिन उन्होंने कुछ प्रॉपर्टी को डैमेज किया था.
When he was taken into custody in that first misdemeanor case, there was a PSA that suggested that cash bail was appropriate based on 2 or more prior failures to appear.
जब पहली बार इनका केस हुआ था तो उसमें उन्होंने इनको एक पैसा बिल दिया गया था चूंकि 2 पिछली बार नहीं आए थे ये अदालत में.
It wasn't long before he picked up the felony charge and had a $500 cash bail set.
और समय के बाद इन्होंने एक felony चार्ज लिया उसमें $500 बेल हुआ.
He remained in custody for a period of time, presumably because he couldn't post that bail, before being released to a signature bond with pretrial services.
उसके बाद कुछ दिन ये जेल में रहे थे चूंकि इनके पास पैसा नहीं था और जब इनको छोड़ा गया प्रीट्रायल सर्विसेज के लिए.
The pretrial services participation has been eventful.
वो ठीक से काम करते हैं प्रीट्रायल सर्विसेज में.
There were 2 different violation reports regarding him being in the Capitol Square area ban location.
2 बार कैपिटल स्क्वायर एरिया में चले गए थे जहां पर इनको नहीं जाना था.
Those and there were 2 reports, but describing multiple instances of that presence there.
2 रिपोर्ट थी लेकिन ये वहां कई बार गए थे.
To Mr. Singh's credit, I think he was largely, as noted by defense counsel, compliant with the program requirements in terms of reporting and the like.
लेकिन जैसे इनसे कहा गया था कि प्रीट्रायल सर्विसेज में रिपोर्ट करें तो वो करते थे.
I also recognize that one of those violation reports contains information suggesting that it's likely he was on the square in either a bus or a moving motor vehicle rather than just being there.
और लगता है एक बार तो खाली किसी बस में थे और किसी गाड़ी में थे वहां पर नहीं थे.
I'm concerned then, though, that there's very little time between those violation reports and picking up these new charges.
लेकिन ज्यादा समय नहीं हुआ था जो इन्होंने वायलेशन की थी और जब पहली गलत किया था.
In fact, the judge directed that the felony case be scheduled for a bail hearing, which I don't think even had an opportunity to be scheduled before he was picked up on the new charges.
और जज ने कहा था कि बेल हियरिंग हो लेकिन उसके पहले भी इन्होंने गलत काम कर दिए थे.
There was a finding made at the initial appearance in the felony case that a $500 cash bail was necessary.
उस समय कहा गया था कि $500 कैश की जरूरत है.
With the new charges, I don't think I should set a total bail at less than that on these cases.
इनके पास नई चार्ज है उसमें पहले से पैसा कम नहीं दे सकता हूँ.
I do respect the point made by the defense that the new charge is charged as a misdemeanor case, despite the fact that he would have been on felony bond at the time.
मैं मानता हूँ कि ये नया चार्ज था ये खाली felony misdemeanor है लेकिन उस समय ये बॉन्ड पे थे.
That probably should result in a lower bail in that case than in the case for which he's charged with a felony level assaultive crime.
उसके लिए थोड़ा पैसा कम होगा नए केस के बाद.
I'll grant the state's request for a $300 cash bail in the felony case.
मैं मानता हूँ जो गवर्नमेंट कह रही है $300 felony में.
I'll set the $200 or a $200 cash bail in the misdemeanor case.
$200 cash bail misdemeanor में.
In the felony case, I'll continue the previous conditions of bond, but I'm not inclined to continue the pretrial services participation.
लेकिन जो पहली बात है उसमें वो मैं बॉन्ड नहीं लगाऊंगा, लेकिन फ्री ट्रायल सर्विसेज की जरूरत अब नहीं होगी।
It doesn't seem to have really prevented him getting picked up on new charges rather promptly. There were
चूंकि
multiple violations reports
चूंकि
without, I'll stop the sentence so the interpreter can do his work.
क्योंकि वो तुरंत गलत काम करते रहते थे जब बाहर निकले।
I recognize that the timing probably prevented much of a response to those violation reports, but there really wasn't much of one in any event.
लगता है समय ज्यादा नहीं था, लेकिन जरूरत भी नहीं थी समय की उस समय उसके बारे में।
It's also not entirely obvious to me why we would need pretrial services to monitor Mr. Singh's presence on the Capitol Square in response to an allegation of an assault occurring in the jail.
मेरी प्रॉपर्टी वहां थी, मेरे बैग वहां जमा थे, इसलिए वो लेने गया 2 बार।
My property was there and I just went there to pick up my stuff.
जब मेरे को पुलिस ने अरेस्ट किया वहां कैपिटल से, मेरा बैग वहां था।
The police arrested me near the Capitol because my bag was there.
और मैं इस बार कोई गलती नहीं करूंगा, मैं वादा करता हूं। मेरे को
Amar, I will talk to you later. I'm going to
जी,
ask
मैं
you
आपसे
to not make any statements.
मैं आपसे बाद में बात करूंगा, अभी कुछ मत बोलिए।
So I think I'm not going to require ongoing pretrial services participation. He had that opportunity as a way of getting out, wasn't able to keep staying out, and I don't know that there's a great reason to reimpose that requirement at this point.
तो मैं इनको प्रीस्टाइल सर्विसेज नहीं दूंगा, चूंकि इनके पास पहले थी, लेकिन उसके बाद भी ये फिर से जेल में आ गए, तो उनकी अब जरूरत नहीं है।
And I believe we're past prelim in the felony case, so both cases should be ready to be sent to Judge White for further proceedings.
तो अब प्रीलिम की बात तो खत्म हो गई है, तो दोनों केस अब जज वाइट के पास जाने चाहिए।
The clerk reminds me that I didn't explicitly state the condition of bond in the misdemeanor case that he not be at the shelter on Zaire Road, and I am going to adopt that condition. It's appropriate.
तो ये समझ जाइए, आप शेल्टर जाहिर रोड पर है, वहां पर आप नहीं जा सकते हैं।
I should also just note for the record that the booking sheet indicates that federal immigration authorities sought for Mr. Singh to be held. It looks like that's not being honored by the jail pursuant to the sheriff's policies.
और इमिग्रेशन सर्विसेज ने कहा है कि इनको उनको देना चाहिए, लेकिन जेल उसकी बात अभी नहीं ठीक कर रही है।
I think we took care of everything for this hearing, but I'll invite anything else from council.
सब कुछ तो हो गया, और कुछ किसी को कहना है?
क्या
Nothing from-
कंडीशन क्या है अभी मेरी?
फिर से बोलिए।
बेल कंडीशन क्या है अभी?
What are my conditions now?
Yep, you're going to get them in writing, but in the felony case, you can't be back at the Capitol or on the Capitol Square or have contact with Bruce N.
आप वापस नहीं जा सकते हैं कैपिटल पे, और आपको कोई कांटेक्ट नहीं होना चाहिए ब्रूस एन से, और आपको सारे कंडीशंस लिख के दे देंगे।
And in the misdemeanor case, there'll be a condition that you not be at the shelter on Zaire Road.
और मिस्टरमिनर केस में यह है कि आप जाहिर रोड के शेल्टर पे वापस नहीं जा सकते हैं।
और बेल कंडीशन क्या है मेरी?
और what are my bail conditions?
And the clerk also points out that there is still the other misdemeanor condition, which has also a condition not to be at the Capitol Square.
और जो मिसडिमिनर केस है उसके कारण भी लिखा गया है आपको कि आप कैपिटल पे नहीं जा सकते हैं।
And you'll be given copies of this in writing and be required to sign them before you get released. So make sure you read that carefully and understand them before agreeing.
आपको सारी चीजें ये लिख के दे देंगे, और जेल से बाहर जाने से पहले आपको उसको पढ़ना पड़ेगा और उस पे साइन करना पड़ेगा।
अभी कोई जुर्माना है, पैसा देना पड़ेगा मेरे को?
Do I have to give any money?
There would be a total of $500 in order to be released.
हाँ, $500 देना पड़ेगा बाहर आने के
नहीं,
लिए।
आप कम नहीं कर सकते? पूछना, मेरा होमलेस हूँ, मेरे पास पैसा नहीं है।
Can you reduce that? I'm homeless. I have no money.
Nope, but you can ask the judge assigned to the case to do so. You and your lawyer can talk about a process for doing that.
नहीं, लेकिन ऐसा है, जो जज है आपके केस में, उनसे आपका एडवोकेट बात करेगा और आप भी उनसे पूछ सकते हैं.
ठीक है.
All right.
Niels, did you apply bail reduction for me?
Uh, my attorney, are you going to apply for bail reduction for me?
We'll talk about that later, Amar.
उसके बाद हम लोग बाद में बात करेंगे.
Okay, good luck, sir. And thank you for your help today too, Bhaskar sir.
शुभ दिन. धन्यवाद भास्कर जी. Thank you, Honor.
Next is MARLO Phillips.
Hear about bail, okay?
Call the case of the state versus Marlo Phillips Jr. It is case 26 CM5. Appearances, please.
Cameron Davies for the state of Wisconsin.
Marlo Phillips is present in court with Attorney Tracy Lencioni. This is a special appearance. We have received a copy of the criminal complaint. We waive formal reading. I do need to provide an updated mailing address for Mr. Phillips. I have the job center on Aberg Avenue.
Oh, address is still the same. I don't know why they put that.
So it's 11.
Yeah, 11.
So I apologize. The address on the complaint is the proper mailing address.
208.
Okay, real good. Sounds like we'll get that updated with the apartment number. And I forgot, Attorney Lencioni, does he qualify for a public defender?
Well, you didn't get anything. I didn't get that far. When we spoke with Mr. Phillips, he did not qualify.
Okay, so Mr. Phillips, the deputy is handing you an information sheet. It describes how you can always reapply with the public defender. Sometimes incomes change or you want them to recheck the numbers or whatever, any of that's fine. You also could hire a lawyer on your own. You could represent yourself. If they still say no and you don't really think you have the dough to hire a lawyer on your own, there's a process for applying through the clerk of court's office too. You're in good hands for today. You have a very experienced public defender who'll help you. We're going to get this case assigned to Judge Highland in branch 14. That's because of co-defendant branch assignment issues. State of a position regarding bail.
Before I give my position on bail, it's my understanding there may be a victim present who would like to make a statement.
I do see Denise Jefferson logged in, whose name corresponds with some initials in the complaint. So yeah, Ms. Jefferson, if there's something you think we ought to know about bail or conditions of bail, now's a good time. Go ahead.
Yeah, so me and Marlo share a child in common that he is very like active with. My son is strictly breastfed, so he's exclusively breastfed, and I can't leave him alone with Marlo, which kind of makes it impossible to have like a third party or like traditional visitation. And then also he's seen at the doctor at least 2 times a month, and Marlo is very like present for these appointments each time. And I want him to be able to continue to be there for our child.
All right, I appreciate that information.
And I also want to state that I do live in Bloomington, so it's not like it would be like an everyday like contact thing. It would be strictly for like our child, basically.
And I wasn't quite able to hear that. Did you say you live in Bloomington?
Yeah, Illinois.
Okay, got it. Yeah. Now I understand. Thank you. State of a position on bail?
The state will be requesting a signature bond. The state would ask for non-monetary conditions that the defendant have no contact with Denise J. except via third parties for the purposes of child custody exchanges. While I understand the victim's wishes, I think at this time, given the violence outlined in the criminal complaint, as well as the threats, specifically as they relate to firearms and shooting, is enough to make the state believe that at this time, no in-person contact is appropriate.
And I'm just taking a little bit closer look at the complaint, but before I finish that up, Attorney Lencioni, maybe you can shed some light on this.
Just.
Okay.
I want to be sure. But I didn't respond. He's asking for signature bond. I know he does.
Yeah.
He's saying no contact. And Denise should be an accept.
So our next
Change.
whether be paid to be.
She's third person. So want to be present for doctors and
Yes.
appointments. All right. So we don't have any objection to a signature bond, nor do we have any objection to the no contact with Denise J. Except through a third person and for the purpose of placement or child exchange. But what I did hear Denise J. Say in further remarks regarding the contact is that she would want Mr. Phillips to continue to be present for doctor's appointments, I believe. And so I would ask that the court only consider adding that language and carving out another exception to the no contact.
Okay. Any response from the state?
I'll just object to that without argument.
So, I think I've had the opportunity to handle some family court cases involving Ms. Jefferson and issues regarding the child and trying to get some things figured out in that regard. Ms. Jefferson, am I remembering that correctly? Is this the case where, are you involved in the case where it's been very, very difficult to get the child support agency to sort of establish paternity? Well, Mr. Phillips, if you just asked that question.
So sorry.
No, there was nothing wrong with what you did.
Because I tell her to take care of her other kids.
Yeah,
Her
no,
baby dad's
I'm saying that because I sort of remember that this has been, that's been a kind of a disaster for reasons that are outside the control of either of you. That, yeah.
And we've been through hell. I've been trying to help her get it and it's been through hell. She's been literally going through hell trying to get it, so.
Okay. And I raise that point only because I know it, because it supports the idea that there's an ongoing relationship with the child and that sort of thing. Not that it makes a lot of difference, I don't think, in terms of the actual bail result today. It's not 100% clear to me, I guess, whether there really is a disagreement between the parties about the bail or conditions of bail. I think the two live parties to the case, that is the state and the defense, agree that a signature bond's appropriate, that it's appropriate that there not be contact with Denise J. except through third parties for the purposes of child custody exchange. I understand the point made by Ms. Jackson or Ms. Jefferson about breastfeeding and what placement might look like and all of that. I just don't know that we're at the point where we can resolve that issue here today. We do have to deal with the issue of safety for all concerned. And I think at this point, what's been suggested as a bail condition is probably about the best we can do in that regard. So I'll adopt that request. We'll get a not guilty plea entered for Mr. Phillips, and we'll get it scheduled for further proceedings. I guess that's about all we can do for today. Good luck to you, Ms. Jefferson. Good to speak with you again, and I wish you the best, Mr. Phillips.
Thank you so much, Earl.
You're
So
welcome. Bye-bye.
he would not be allowed to attend doctor's appointments.
I'm sorry, I've totally forgot that part of the issue.
Because of my.
Yeah, I'll make an exception to the no contact for presence at a scheduled doctor's appointment. I think that's a relatively risk-free proposition.
Thank you so much.
Sure. Thank you for reminding me of that.
Next is Charles Madison appearing via Zoom.
It is. All right, we'll call the case of the state versus Charles Madison. It's case 26F04. Appearances, please.
Cameron Davies for the people of Dane County. The defendant appears via Zoom in custody without counsel.
Well, Mr. Madison, some good news for you. It looks like the DA decided not to charge you with any criminal offenses. They have charged you with 2 ordinance violations. So it's more like getting a couple of tickets. One is for disorderly conduct and the other is for possession of drug paraphernalia. You have some options. One option is to enter a not guilty plea to the charges. If you do that, we'll have you released from jail without any kind of bail. You won't have to post a bail. You'd have further court dates. You'd have the right to try to find a lawyer or look into your options more fully, and you'd preserve your right to potentially have a trial on the charges. So not guilty plea is certainly an option. If you think you might want to just resolve these matters here today, the county likely has some offer to do that. Do you want to enter the not guilty plea, or do you want to hear an offer from the county?
Get like a signature bond to get out of here.
Well, you're going to get out of here pretty much either way. And it's better than having a signature bond, because you just aren't going to have a bond at all. We would just release you with either another court date or with like a payment plan if you decided you wanted to take their offer.
What is the offer?
Good question.
That county would resolve for court costs.
So I think, and that would involve a plea to both counts, I assume?
Actually, I believe it was one. If you give me one moment to double check which one. Yeah, it would be either one at his choice.
So, Mr. Madison, I don't know if you were able to hear that, but I think the offer is that if you plead guilty or no contest to either of the counts, you'd owe $114.50, and then the other account would be dismissed.
Well, I would just plead no contest.
Okay. Do you prefer to be found guilty of disorderly conduct or possession of drug paraphernalia?
I still be getting released today, right?
Yes, absolutely. It's just a matter of you get the county's willing to let you just choose which of the two charges you want it to be.
I wanted to say no contest to disorderly conduct.
Okay, that's fine. That's count one. I'll accept that no contest plea to the non-criminal charge. We'll find you guilty of that and impose the $114.50. We'll set you up with some time to pay that. You don't have to pay it to get out. It's just like a fine. Yep, and then we'll dismiss the paraphernalia count on the county's motion. You're all set to go.
All right.
Take care, Mr. Madison. Good luck.
Have a good day.
You too. Bye-bye.
All right.
Next is Ramogi CARR.
Okay, we'll call the case of the state versus Ramogi CARR, case 26 CF1. Appearances, please.
Cameron Davies for the state of Wisconsin.
Mr. Ramogi CARR is present in court with Attorney Tracy Lencioni. This is a special appearance. Excuse me, we have received a copy of the criminal complaint. We waive formal reading. The address on Brody Drive does appear to be the proper mailing address, and Mr. CARR is eligible for a public defender.
All right, thank you. Mr. CARR does have an open felony case assigned to Judge Kondar, as suggested by the complaint. We'll get this new case assigned to the same judge. Does the state have a position regarding bail?
I'll ask for $1,000 cash bail. I will ask for non-monetary conditions that the defendant first not operate a motor vehicle, and second that he not possess or consume any alcohol. The defendant is on bail for an OWI fit, so mandatory prison, and he's pretty clearly and flagrantly violating specific conditions of bail. Looks like he had an open container in his car. He has a lifetime IID, lifetime revocation. He's got conditions to not drink and not drive. He's also got expired registration, no front plates. Given this behavior while on bail for a case with some significant exposure, I do think cash bail is appropriate here.
And Attorney Lencioni?
As I mentioned, Commissioner, Mr. CARR is eligible for a public defender and does have one assigned to the case that was pending previously that was referenced by the state. He has a local Madison address. He does pay rent there. He signed a lease for this apartment. He's resided in Dane County all of his life. He has 4 minor children ranging in ages from 16 to 2 years old that reside with him. He's currently earning an income doing odd jobs. Prior to that, he was steadily employed at a local Madison company. He simply cannot afford $1,000 cash bail, nor did I hear any reference to there being missed court appearances, and these are not Act 3 offenses. So I would ask for a signature bond, despite the fact that Mr. CARR is alleged to have committed these new crimes while alleged to have committed an OWI of a felony level. So for those reasons, we'd ask for a signature bond.
Thank you. Any response from the state?
No, not at this time.
Well, it's concerning that he was released on a signature bond in, as the state terms it, a mandatory prison OWI fifth case. Of course, it's mandatory prison only if he's convicted. That hasn't happened yet, but it's a serious set of charges to be sure. I think it rises out of a case involving a near crash. Then we have this new case where it's alleged that he went through a red light, gets stopped, and as the state points out, there's kind of a lot wrong here in terms of the fact that he's not supposed to be driving, he's not supposed to be drinking. It's alleged that both are the case. Not too worried about the registration stuff here for today or the window tint, but those aren't the biggest deal. The positive, I think, is it looks like he was pretty cooperative with the police officer. I don't see an indication here of a bunch of problems in that regard. I agree with the defense that I haven't heard a big history of missing court. That doesn't seem to be the situation here. Let me just take a little bit closer look at the prior driving record. It's probably relevant to this. Couple of prior operating after revocation convictions as well. I think it's a cash bail situation. I don't think it needs to be as much as proposed by the state. I'll set cash bail at $500 here. I'll order that he not operate a motor vehicle. I will have there still be an order that he not consume alcohol. Should we put on, well, the other case is scheduled for prelim on January 29th. We could put this on at the same time, but I think that is just outside the time limits.
So
Or we could talk about shuffling dates around or something too.
you think? So the preliminary for your older case is set January 9th. He's asking if you want us this preliminary that same date, but normally would have to be 17. Do you want one date for preliminary hearing in this case and then a different date for preliminary? Okay, so you want to waive time limits at the prelim. Okay, so could we waive time limits, but just have the prelim set on the same date as the other case?
Yes, that makes
Yes.
perfect sense.
Mhm.
We'll schedule it straight away for a prelim on the same date and time. All right, very good. Mr. Carr, good luck to you. I hope things get better.
Next is Tony LEAS.
All right, we'll call the cases of the state versus Tony LEAS. I think I heard you just pronounced the name and I forgot what how it's said. LEAS. LEAS, thank you. So we'll call those cases, their cases 26 CF2 and 26 CF10. Appearances, please.
Cameron Davies for the state of Wisconsin.
Mr. Tony Lease appears in court with Attorney Tracy Lencioni. This is a special appearance. Excuse me, we have received a copy of both criminal complaints. We waive formal reading. The address on the complaint is the proper mailing address. And Mr. Lease is eligible for a public defender.
All right, thank you. Does the state have a position regarding, oh, I'm sorry, actually, I should note that I think there is a hold. Maybe there's a specific branch to assign the case to.
If there is, I looked through the information on the DOC locator. I tried to cross-reference that with Spillman on the jail computer. I really couldn't put my finger down on it for sure, but it sure seems like it probably needs to get assigned to branch 5.
Well, that's confidence inspiring, but let's look and see what we have here.
There's a case out of Milwaukee County that is noted in a format that I'm not familiar with. Obviously, the automated system doesn't link to it. It's F920739. Maybe the probation's out of that. I really can't tell.
Well, the booking information says that the ES hold stems from a prior felony OWI case. So I think that tends to tie, well, I was gonna say, I think that tends to tie in with the Judge McNamara branch 5 analysis. Except the most recent case I see from there has a discharge from supervision docket entry.
I believe I went through every case that was listed on the DOC locator, they all provided that status, except for the one that I can't access, so the one.
Okay,
It's
Well-
like a current file.
what, if nobody has a strong objection to it, maybe we assign it to Judge McNamara, because it seems like it's the best guess. And I don't think that would prejudice the defendant's right of the substitute still, because it's an administrative assignment to that judge.
I hate the UI. Dane County. The Milwaukee case is 35 years old and it was cleared 35 years ago.
Okay.
Yeah, I kind of recognize the old Milwaukee case number format, and it probably would have been from the early nineties, like he said. Yeah, but Attorney Lencioni, I don't know if you have a position on the branch assignment issue.
Well, you know, I like accuracy. So, if you think it's appropriately possibly assigned to Judge McNamara, we're fine with sending
Yeah,
it with.
I think doing it that way actually maybe preserves more options for him than the other way around. But at any rate, if the state doesn't object to branch 5, maybe we'll talk about bail.
I've got no objection to the assignment issue with regards to bail. In 26 CF 2, the state will be requesting $1,000 cash bail. I will ask for non-monetary conditions that the defendant first not operate a motor vehicle, and second, that he not possess or consume any alcohol. Would also ask that if he's able to post, he report to Dane County Pretrial Services for remote alcohol monitoring. In the other case, 26 CF 10, I would ask for $500 cash bail. There, I would ask for the sole non-monetary condition that the defendant have no contact with Officer, I will try to pronounce it, Jugum, spell it TJUGUM, except in their official capacity as a law enforcement officer. In terms of support for that cash bail request, the defendant was on extended supervision, as best as we can tell, for an OWI. Last time, I believe he got 5 in and 4 out, 4 and 5 out, which would line up closely to that and is pretty significant exposure. He's now picked up another new one, which features lengthy mandatory prison time if he is convicted. There's also the behavior towards law enforcement in 26 CF 10. I think all told, the amounts requested by the state are appropriate and necessary here.
And that's a total of $1,500.
That is correct.
Attorney Lencioni.
We'd ask for signature bonds, Commissioner. These are 2 separate complaints, but it seems to be one long alleged day or evening. Not 2 distinct, not booked in, charged, released, then booked in again, as I'm sure the court picked up on.
There are some not date anomalies in
Yes,
the
there are.
battery, or not the battery, but the threat complaint.
Yes.
But I read it the same way, that it was kind of one continuous course of events. Yes,
I think it's just one day too early,
sure.
but anyway, yes. Mr. Leas has provided an address in Wanakee. He pays rent there. His name is on the lease at that residence. He has a spouse. He has children who live with him, all in the area. And, you know, this seems to be a situation where, you know, Mr. Leas is not unfamiliar with serving prison time in connection with OWI-related offenses. He has been released on ES after serving prison time, but nowhere in the state's recitation in support of cash bail do I hear that there was missed court appearances. Now, I have personally worked with Mr. Leas in the past. I know that he, during my representation of him, would dutifully attend court when required to do so. That is my memory of my working relationship with him. And up until his custody, Mr. Leas was employed at a pretty well-known manufacturing company in his city of residence. So he's not, even if you set signature bonds with those conditions, and there's no disputing the proposed non-monetary conditions, but even if the court set signature bonds, he would not get out because of the DOC hold, which at this point the future in that regard remains uncertain. But for those reasons and with lack of a criminal history, or lack of a history of missing court, I would advocate for signature bonds.
I did look at the CCAP entry for the 2014 OWI case, which I think was the most recent one. So we're talking some time ago. It looks like a $2,000 cash bail was set at that time. Anything else from either party, but I should call on the state more specifically.
Nothing further, Your Honor.
Nothing more.
Well, I mean, I think we've talked about this a little bit already, but I'll reiterate the point. I do think this is alleged to be sort of one continuous set of events, even though there's the date anomaly. I understand that there to have been the OWI arrest, him being brought to the jail, and then the spouting off that becomes the basis for the threats complaint in 26 CF10. So the fact that there are two complaints, I really don't put a lot of weight on. It probably all could have been on one complaint. I assume it just got charged separately because sometimes the state has a habit of doing that when there's a traffic and a non-traffic referral. And probably these referrals also would have come separately from two different law enforcement agencies, given one event occurring in the jail while the other occurring out on the street. So I'm not holding it against either party that we have two complaints. I think it's one big situation. Still, because I have two complaints, I have to set some sort of a bail on each, but I'm conceptualizing it all as one in terms of totals, so to speak. I think the state could make a very compelling argument for a much greater bail than what's been proposed here. This is a ninth offense operating under the influence. There are very few people who pick up a ninth offense OWI, even with now that there's lifetime counting and all of that. The law regards that as extremely serious behavior to the extent that there is mandatory minimum prison. I guess I do get the argument that that's something that he has experienced before and didn't apparently run from. I'm also not sure how much opportunity he would have had to have, because I think he's been basically continuously on some form of supervision during the course of all of these last several violations, meaning that there probably would also been holds and revocations and the like. I'm not going to set cash bail on this new case now with mandatory minimum. Is it 5 in? I think.
3.
3 in. Yeah, thank you. With a mandatory minimum 3 in at less than what got set for a cash bail 11 years ago on the last offense. I'll set a cash bail at $2,000 in case 26 CF2. I think the $500 requested in case 10 is probably appropriate. I'll adopt that. In case 2, I'll have there be conditions that he not operate a motor vehicle and that he not consume any alcohol. In case 10, I'll adopt the requested condition that he have no contact with Deputy Chugum, except in that deputy's official capacity. I know that this isn't a whole lot different than the state's request. It's only marginally higher ultimately. But I guess I think it's the least that ought to get said at this point. And I'm not trying to be on your case, Mr. LEAS, except it's kind of my job, is I have to look at the bail conditions and the risks and all of that. And this just is not a good situation. The fortunate thing about it is that I believe in his contact with at least the Wanakee police officers out on the streets, he was fairly cooperative. I don't see any indications to the contrary. The other thing is, despite there being a lot of concern about the possibility of somebody being hurt here, that didn't happen. And that's good. It means you're going to get this dealt with and get put behind you, but it's going to be a process. Should we get it scheduled, both cases scheduled for a prelim within the next 10 days?
Yes, please.
All right. Mr. LEAS, I do hope things improve for you. Good luck to you. You're welcome.
Next is Mark Sanders appearing via Zoom.
Okay, I think we're ready to call the case of the state versus Mark Sanders. It's case 26 CF8. Appearances, please.
Cameron Davies for the state of Wisconsin.
Mr. Mark Sanders appears for this proceeding by video from the Dane County Jail. In the courtroom is Attorney Tracy Lencioni. Mr. Sanders, are you able to hear everything that's been said so far?
Yes, ma'am.
Thank you. And my last question, I believe, is did you get a copy of the criminal complaint that contains the single charge the state's filing against you?
Yes, ma'am.
All right. So we acknowledge receipt of the complaint. We waive formal reading. Mr. Sanders, I told a fib. I have to ask you one more question. Is the 2314 Montana Avenue in Sun Prairie your current mailing address?
No, ma'am. I'm at Berg Avenue, 1819, I think.
That
Thank
sounds
you.
right. Yeah, we'll get that updated.
Okay, thank you. And then I do not know if Mr. Sanders qualifies for public defender representation on this case, even though I know he is currently represented by a public defender from my office.
Right, he does have the 3 open felony cases assigned to Judge McNamara. We'll get this case sent there too. Does the state have a position regarding bail?
Yes, I will be requesting $250 cash bail in this case. I would ask for the sole non-monetary condition that the defendant be banned from the State Street, Langdon Street area per ban map. In terms of support for that cash bail, I would note that the defendant is violating specific conditions of bail in felony cases. I'd also note bench warrants from the past year and a half or so, one from August 2nd of 2024, one from March 24th of 2025, one from July 20th of 2025, one from August 21st of 2025, and one from September 10th of 2025. So I think when weighing the factors in a case like this, some amount of cash bail is likely appropriate.
And maybe you can correct me if I'm wrong. I think there's a $250 cash bail posted in each of the 3 pending cases.
I think that's correct.
Attorney Lencioni, the defense position.
I would just briefly add, Commissioner, the, public defender eligibility for Mr. Sanders. But I would point out that the complaint alleges that Mr. Sanders was located on West Gorham, not on State or Langdon. I would just point that out. I'm not saying it's not included on the map. I'm just saying it is a street that is not named in the title of the map.
I follow what you're saying. Yeah.
I was just going to pick up my brother that night.
Okay, the audio is really low, but Mr. Sanders, I think you were saying that you were picking up your brother, and I do see a statement about that in the complaint too.
Yes, sir. And I also
Mr. Sanders, I would just caution you not to talk about the facts of the case beyond maybe what is read in the criminal complaint, because that's not your own words being potentially used against you.
Okay.
Yeah, that's probably pretty good advice. Well, if I'm picturing this location correctly, it is true that it's not on a street named either State or Langdon, but it would be exceedingly close to the intersection with State Street. So kind of difficult to see how he wouldn't be aware that it would be a violation of the conditions of bond. There also is an allegation of the consumption of alcohol, which I think is alleged. Well, I'm not so sure it is alleged to be a violation. It's referenced, but I don't know that it said that that was a condition of bond anywhere.
Yeah, I have no drink condition.
Let me just take a look at one other thing here before I make a decision fully.
Your Honor, it was an honest mistake and it won't happen again. I have kids, a job that I have to get back to.
Sure. Yeah, and to be clear, I don't think there is a no drink condition in any of the pending cases, so I don't think that that part of it would be a violation of anything. As I understand this complaint, it's basically a standalone count for allegedly being in the prohibited state and Langdon ban area. The trouble I have here is we're on case number 4. He's posted cash bail in all 3 of those cases. And the most recent of those cases is the one where he posted a $250 cash bail with a promise to stay out of this area. And I don't know whether he was picking up his brother or just there, but it's 3 in the morning in a bar. It's not as though it's, sort of like going to work or something along those lines. The state's request is for me to set the same bail that's been set in the 3 other cases. It's hard for me to criticize that other than the note that it might be less than what could otherwise be called for under the theory of some escalation as more charges get picked up. They're not asking for that. I'm not going to set it higher, but I'll set cash bail at the $250. I'll continue or set, I guess, in this case, again, the condition that he not be in the state and Langdon ban area. Despite all of the talking on my part about alcohol, I don't think there's been a request to set that as a condition, and I'm not going to at this point. Should we put on a prelim within the next 20 days?
Yes, please.
Okay, we'll get that scheduled. Good luck to you, Mr. Sanders. Take care.
Next, DELSHAE Vance for a portraiture.
All right, we'll call the case of the county versus DELSHAE Vance, case 26F06. Appearances, please.
Cameron Davies for the people of Dane County. The defendant appears in person in custody without counsel.
All right, you're Mr. Vance?
Yes.
Okay. Mr. Vance, a couple of things here to talk about. One is that the DA decided not to charge you with a criminal offense. So the complaint you have there is for a non-criminal ordinance violation. It's like a ticket for disorderly conduct. One option you would have to that is to enter a not guilty plea to the charge. If you do that, we'll release you from the jail.
Yeah, I'm not guilty. That's what I'm saying.
Okay. All right, and that's fine. There's also,
signature.
it's even better than that because you're not charged with a crime. You wouldn't even have to sign a bond. We'd just give you a court date.
Give you a court.
Yep, we can do that. There's one other technical point that I think I should raise. The clerk just brought it to my attention, and that's that the complaint we have on file actually isn't signed by either a court officer or an assistant district attorney. Maybe being a non-criminal complaint, that's not something you care about a whole lot, Mr. Vance. But if you're okay with being released today and not being concerned about 2 missing signatures on the bottom of the complaint, we can just move forward from here.
I wanna leave and then leave today, get released if I can.
Yeah, I think we're gonna accomplish that either way.
Okay, thank you.
Yeah, do you care if they file a new piece of paper that has 2 signatures on the bottom of it, or are you good with what it is?
What is it bad or is it?
It's probably not, in the big scheme of things, it's probably not super important, but technically, when there's a complaint that's filed, it's supposed to have
like what
a signature of some sort of a witness or law enforcement officer and a signature from an assistant district attorney.
So do you want that on?
Well, it's up to you, I guess, is the bottom line. It's not there unless the county has some brilliant ability to file an amended one here in court. I think you'd be entitled to dismissal of the complaint. That said, I'm not sure that it would advantage you a whole lot because probably they would just file a new complaint and give you another court date at some point anyway.
So what do I want? I'm confused what you're asking me, Judge.
Sure. If your goal is to get out of here and you don't really care about the paperwork, I can just take the not guilty plea from you. We'll get you another court date and it'll have preserved all your options.
Otherwise,
if you're a real stickler for paperwork stuff, you could say, I want a copy of that criminal complaint that has 2 electronic signatures on the bottom of it.
Is that going to be a bad thing, or then I don't get released or something, or what?
It wouldn't make a difference. We'd let you out either way.
I won't make it. So do I want the papers then?
That's the question.
Yeah, sure. I guess, do I want the papers? Sure. I mean,
you'd like to have a complaint that's not defective, that has the signatures on the bottom?
I don't understand what the signatures are doing. I don't understand.
Okay.
I've never been in.
Mr. Davies, any argument for why this is a sufficient complaint?
I don't at this time. It's wild that it made it through the system. My understanding is that it couldn't be filed without signatures, but it appears to have been filed without signatures. So
Yeah, I think that there is a pleading requirement that if the county elects to proceed on a long form complaint of this sort, that there does have to be a signature on the bottom. It has to have been authorized for filing. And the charging document has to reflect that. It probably was authorized by somebody or it wouldn't have gotten to this point. But so I'll dismiss the complaint without prejudice. That means that you're gonna be just free to go. You don't have a charge pending at this point. If at some point the county elects to file a new complaint, they should be making an effort to summons you into court.
To the court, okay.
Right, yep. Okay, well, you're all set for today, Mr. Vance. Good luck.
Do I have to sign
Nope, you're just gonna be able to go.
I'll be able to go get my daughter and leave then, or? That,
I don't know what the process will be for getting you booked out, but you're gonna be released.
well, like, not like today, right? I leave
Yeah.
today, right?
Yeah, it's probably gonna be like an hour or something.
Okay, thank you, that's all that.
You're all set, Mr. Vance. Take care.
Thank you, thank you.
Bye-bye.
Next is Joshua Berkhan appearing via Zoom. I never.
I'm pedantic. I don't know that I would have noticed that. All right, let's call the case of the state versus Joshua Berkhan, case 25 CF 2681. Appearances, please.
Cameron Davies for the state of Wisconsin.
Mr. Joshua Berkhan is appearing for this proceeding by video from the Dane County Jail. In the courtroom is attorney Tracy Lencioni. This is a special appearance. Mr. Berkhan, can you hear everything that has been said so far?
Come up so they can see you.
There he is. Yeah, Mr. Berkhan, can you hear me okay? And Deputy, I can't tell whether he's responding and I'm unable to hear it or if he's just not responding.
He's saying yes.
Oh, good. Okay. Glad to hear that. So, we are here on return of a bench warrant. It looks like it was issued on December 22nd after a missed court hearing. Looks like that was intended to be a return date on a competency evaluation. There had, according to the evaluator, been some unsuccessful attempts to contact the defendant for the purposes of conducting that examination. Maybe we'll start with the state for any position regarding, well, what we should do next.
Sure, I'm gonna ask for $500 cash bail to be imposed on this case. I'll start by noting he does, by my count, have a number of open cases up in Marathon County as well. That indicates some connection way up there that concerns me. I would also note prior missed court, or at least bench warrants that were issued. There's one from a little over 2 years ago out of Marathon County. That was in 2023. In terms of here in Dane County, I see bench warrants issued May 1st of 2023, October 25th of 2023, and December 23rd of 2025, the most recent one. I think given connections to another county, given the number of open cases, given the prior missed court appearances, and given the no contact with the competency evaluator, I do have concerns about his willingness to voluntarily come to court, his willingness to voluntarily interact with the court, and I do think cash bail is appropriate to get this case moving.
And while you were stating that, I did try to follow along on CCAP. I think there's 4 misdemeanor cases and 1 open felony case in Marathon County. In the felony case, there's a record made that there were some issues with getting that evaluation conducted. Eventually, Judge Swikes, CVEYKUS, directed that he be held until the evaluation was completed. There is a report on file, though I don't know that I have access to be able to see it or share any information from it anyway. I don't know whether that causes you to want to.
It was never brought into an initial appearance on this case at all in this whole entire court holding. And I was in the area as of the day of the 22nd, but I got abducted and somebody took me over by a speedometer demon, took me over to Milwaukee, and was holding me against my will. So I was actually kind of rescued in this whole entire process, but I never had an initial appearance on any of these charges in Dane County at all.
Okay, I didn't totally follow that recitation of events, but I do see that the warrant was served in Milwaukee, so that's at least somewhat consistent.
I never had served an initial appearance on any of these charges in Dane County.
Well, that's interesting.
Yeah, I never had initial appearance or anything.
Yeah, the court record says that you were, that you appeared by video, probably a little bit like what's happening now.
Never had an attorney. I never had an attorney or anything yet. So I don't understand why, I was in the area on the 22nd, but I got abducted by a person and they took me over to Milwaukee and they rescued me in the process. And I've just been in limbo. I've never had an initial appearance on any of these charges. I don't even know what
Yeah,
the
so
charges are.
I might be able to help out with that because the clerk just pointed out to me that the court record from November 25th in this case says that the initial appearance was conducted. The last sentence says defendant elected not to participate in this hearing. So I guess I'll let that stand as it will, but Attorney Lencioni, maybe you have a position on what we ought to do here.
I do want to point out, if you're reading the notes from November 25th, from that schedule initial appearance that perhaps Mr. BERKHAHN did not participate in, I do just want to make sure that the court is aware that the use of a dangerous weapon enhancer was dismissed at that initial appearance based on the argument by counsel who appeared at that time. I'm afraid I don't have a whole lot of information about Mr. BERKHAHN's situation. I read the same notes as the court is reading about what had been set and the type of proceeding for which Mr. BERKHAHN is alleged to have not appeared. And I do also see that there was a letter filed from the assigned competency evaluator. So beyond, him being, and I honestly, I don't even have any information about whether he qualifies for a public defender for this case. I know that he has been represented in the past by different attorneys from the public defender's office, but I simply don't have any good explanation for the lack of contact that is alleged.
And anything else from the state?
No, Your Honor.
Well, Mr. BERKHAHN is on case number 6 pending across a couple of different counties. He didn't show to court, didn't get in contact with or make himself available for contact with the competency evaluator. That may be not entirely unrelated to the reasons why competency was being evaluated, of course. I recognize that. But there's also apparently some history in that regard in the various Marathon County cases. This is not the sort of case where ordinarily we would be sent in a whole bunch of cash bail. And in fact, Commissioner Osmus didn't. He ordered a signature bond back in November, despite the defendant then electing not to participate in the court proceeding. He's been unheard of since then, until apparently arrested in Milwaukee. I don't see a great alternative here. I'll set the $500 cash bail. I'll I suppose have to order either a new competency evaluation or make sure there's some sort of a referral back to the evaluator to inform him that the defendant is here at the jail. At this point, it would be an outpatient evaluation. I wonder if that referral could also just make reference to the fact that that there is an evaluation on file in the Marathon County cases. It may be that could substitute in some fashion. My goal would not be to have a situation where Mr. BERKHAHN is kept in custody for a greater period of time than is necessary to achieve the goal of getting the evaluation done and appearing in court, all of that. But at this point, I'm not seeing a great alternative to it. And, frankly, nothing I've heard here today gives me the impression that there's no longer a need for the evaluation. So you're all set for today, Mr. BERKHAHN. We'll get things scheduled once this evaluation is conducted. Good luck to you.
Next is Bill and Harold. Bill.
Fine. We're here about it's KAIOULA, proper way. KAIOULA. Okay, thank you.
All right, we'll call the case of the state versus Dylan Kaioula, case 26 CF9. Appearances, please.
Cameron Davies for the state of Wisconsin.
Dylan Kaioula appears in court with attorney Tracy Lencioni. This is a special appearance. We have received a copy of the criminal complaint. Sister Clerk, ma'am. Where do you get mail?
401
401.
East Dean Avenue, Madison, Wisconsin. 53716.
Does Mandy take care of someone who's lived there? Their name is on the mailbox. They would need to be listed. If your name, care of their name, this address.
Yeah, man.
I'm asking you.
There's no, it's just, this is fine.
This is fine.
Yeah, yes.
The address on the complaint is the proper mailing address for Mr. Kaioula, and he is eligible for a public defender.
Thank you. State of a position on bail.
Yes, the state will be requesting $5,000 cash bail. I would ask for non-monetary conditions that the defendant first have no contact with Carol K, that the defendant be banned from the 3800 block of Hepker Road in the town of Burke. Hepker is spelled Hoepker. And I would last request that the defendant not operate a motor vehicle that is not registered in his own name. In terms of support for the cash bail, I'll start by noting the nature of the charges. These are Act 3 offenses, or at least one of them is, I believe.
I believe the burglary would be,
Yeah.
not the others.
I think that's correct. My notes indicate that if proven, this type of case could result in lengthy incarceration and involve the defendant kicking in a door and stealing a vehicle. I would also note prior bench warrants issued against the defendant from October 30th of 2023. That was out of Rock County, as well as October 22nd of 2024 and December 11th of 2024. Both of those were in Dane County.
Thank you. Attorney Lencioni.
The failures to appear and subsequent warrants being issued that the state has cited are at this point over 1 year old. Mr. Kaioula has a local address in Dane County. He has lived in Dane County all of his life, has a young minor child who lives in the area. He is somewhat struggling with housing stability at this time. Until a short time ago, he was employed. He is eligible for public defender representation. I know that in my practice, I have represented individuals who are charged with the similar offense of burglary where there was a person present who have received signature bonds despite it being an Act 3 offense. So we would ask the courts, we would ask that the court set a signature bond and there would be no objection to the non-monetary conditions proposed by the state.
All right, thank you. And any response from the state?
No, Your Honor.
I do want to take a little bit closer look at the complaint. Well, I mean, have no doubt it's true that there have been individuals charged with burglaries since Act 3 came into being that have had signature bonds. I'm sure I've ordered that on a number of occasions. And that might also be true of those burglary charges that have the with person present modifier or enhancement on it. I would take counsel at her word on that. I do think this case is perhaps a little more serious than the average because if I understand it correctly, it isn't just the entry into the property, it's actually kicking down the door with this person sort of noticeably present. There's the subsequent alleged theft of a vehicle. Mr. Gill unfortunately has a not insignificant prior criminal record. In fact, he's charged here with a habitual criminality enhancer for, of all things, a relatively recent conviction for felony bail jumping. I mean, if there's any good news here, I suppose it's that this is alleged to have occurred without somebody getting hurt and not in a minor way. There's a lot of homes where if somebody were kicking down the front door of it, it might be one of their last acts on earth. That was not the case here, and I'm glad for that. I'm glad that Mr. Kaioula is still here. I'm glad that it doesn't appear that there was physical harm caused to the homeowner. All of that is for the positive, but the risks are pretty substantial in this sort of behavior. And again, I don't think I should overlook the prior record either. There's always some degree of subjectivity as to what a correct bail amount is. I think if I'm sitting in the position of CEK, who is said to have had this happen to her in the last few days, the whole concept of bail probably seems sort of frightening and absurd. The law says that Mr. Kaioula is entitled to a bail and to a bail that's not excessive under these circumstances. I don't know that the state's recommendation is excessive, but I also can see a smaller number as being as effective to meet the statutory goals. I'll set cash bail here at $3,000. I am going to order that he not have contact with Carol K. I'll also order that he not be in the 3800 block of Hepker Road. I think I'm going to have the driving condition just be a straight no drive condition, given what's alleged in this complaint. And I think that's probably just a cleaner, better answer at this point. Well, it's also sort of bizarre. I think it's alleged that he basically stole a car and drove it a tiny distance at a relative's house. I don't say that to minimize what's alleged in the complaint. I say it just because it also suggests that it was sort of an unforced error in a lot of ways. Let's get a not guilty plea entered for Mr. Kaioula on the misdemeanor charges. Should we put on a prelim within the next 10 days?
Yes, please.
Absolutely. We'll do that. Good luck to you, Mr. Kaioula.
This way, sir. Next is Tanner DeBlay for a forfeiture. Tanner.
All right, we'll call the case of the county versus Tanner DeBlay, case 26F02. Appearances, please.
Cameron Davies for the people of Dane County. The defendant appears in person, in custody, without counsel.
All right, so Mr. DeBlay, you have some good news here. The DA decided not to charge you with a criminal charge. You are holding a signed copy of an ordinance complaint. It alleges a county ordinance violation for resisting or obstructing. So it's more like a ticket rather than a criminal charge. You still have rights. One right is to enter a not guilty plea to that. If you enter a not guilty plea, we're going to release you from the jail here today. You get another court date. It would preserve your right to have a trial and just to look into your options more fully.
Okay.
If you think you may want to just resolve this case here today, they probably have some offer for a fine of some sort to do that, if you want to hear it.
I could take the fine.
Okay.
Well, depending on how much it is.
Sure, yeah, we'll let you hear it first before you make a decision, not a problem.
The county would resolve for court costs.
It's $114.50.
Yeah, I can deal with that. Do I have to wait or?
You're gonna get out either way, but
Okay.
you'll owe the fine. We'll give you a couple of months to get it paid.
Okay.
Yeah, so I'll take that as a no contest plea to this non-criminal charge, the ticket.
Okay.
we'll impose the 114.50 and we'll get you another court date here in the next room, or not another court date, but rather a payment envelope. You won't have another court date. It has been. You're absolutely right. But hopefully yours is gonna get a little better because you're getting out of here.
Yes.
You're all set then. Take care.
All right, thanks. Next is Antoine Wright.
All right, we'll call the case of the state versus Antoine Wright, case 26 CF5. Appearances, please.
Cameron Davies for the state of Wisconsin.
Mr. Antoine Wright, excuse me, is present in court with Attorney Tracy Lencioni. This is a special appearance. We have received a copy of the criminal complaint and we waive formal reading. The address on the complaint is the proper mailing address. Is it apartment 4?
Yes.
Okay. And when my office spoke with Mr. Wright, he was not eligible for a public defender at that time.
All right, we'll talk about that a little bit more. So Mr. Wright, sometimes the public defender's office decides that you either make too much money or you have too many assets to qualify for a public defender. You're always free to check with them again. If something changes, or you just want them to recheck the numbers. And the sheet that the deputy just gave you describes how to do that. You also could hire a lawyer on your own. You could choose to represent yourself. Or if the public defender still says no, but you really don't think you have the money to hire a lawyer, there's a process for applying through the clerk of court's office. Sometimes they can get you a lawyer with like a payment plan. You're in good hands here today. You've got an experienced public defender who's going to help you for today's here.
Okay.
What's the state's position regarding bail?
The state is recommending a signature bond. The state would ask for non-monetary conditions that the defendant first have no contact with Charles T. and that the defendant be banned from the 7300 block of Manufacturers Drive in Madison.
No objection.
I'll order a signature bond with those conditions. That all appears appropriate. Obviously, what's alleged in the complaint is concerning. Mr. Wright has no prior criminal record. I think, and I recognize this is alleged to have occurred in a workplace setting. That doesn't excuse anything. It's not my intention to say that, but my point is that he has ties, he's got connections, and I think he deserves a chance at the signature bond. So let's do that with those conditions. We'll get a not guilty plea entered on his behalf to any misdemeanor charges. We should talk about the time limits for the next court date.
Just gonna discuss that.
No problem.
Mr. Wright has chosen to waive the time limits.
That's pretty reasonable. We'll get you set up with another court date here in the next room, sir. Good luck to you.
Okay.
Take care now.
Next is DANTRELL Williams.
Hello.
We'll call the case of the state versus Dontrell Williams. It's case 26 CF3. Appearances, please.
Cameron Davies for the state of Wisconsin.
Mr. Dantrell Williams is present in court with Attorney Tracy Lencioni. This is a special appearance. We have received a copy of the criminal complaint. What do you use for mailing it? Job center or that? We should change the mailing address for Mr. Williams to the Job Center on Aberg Avenue, please. If I didn't say it, we waive formal reading of the complaint, and Mr. Williams is eligible for a public defender.
Thank you. It looks like Mr. Williams is on a probation or parole hold. Also, there's an open felony case assigned to Judge Highland, so we need to get this case assigned to that same judge. State of a position regarding bail?
Oh, one moment, Your Honor. I will be requesting, say, $500 cash bail in this case. I would ask for the sole non-monetary condition that the defendant have no contact with Denise J. In terms of the purpose of cash bail, it's an Act 3 eligible offense committed while the defendant was on probation. Or it's not an Act 3 eligible offense. I apologize. I was looking at the co-defendant. Certainly a felony offense. It's a new criminal offense. The defendant was on probation. He had an open criminal case. I think the violation of bail combined with the fact that he was doing it while on supervision leads to some concern about his appearance risk going forward. And I would ask for some amount of cash bail.
Attorney Lencioni.
We are asking for a signature bond. I'm not aware of any prior missed court appearances. Mr. Williams is eligible for public defender representation. Until a short time ago, he was employed at a company in a neighboring county in Rock. He has 4 children, all under the age of 6, who reside in Dane County. He's lived in Dane County for the last 7 years. He is on supervision. I understand that he is in custody on a hold in connection with the DOC. But in light of his indigency, his local ties, and primarily being the DOC hold, I would ask for a signature bond and ask that the DOC make the decision of whether Mr. Williams is released into the community.
Well, the allegation of physical resisting alone is probably sufficient for a $500 cash bail. That sets aside the fact that he's on a felony bail for a series of other Act 3 offenses. I agree that this case is not an Act 3 case, but and he's also on some form of supervision for a felony. I think the state's position is very reasonable. I'll set cash bail at $500. I'll order the no contact condition. We'll get a not guilty plea entered for Mr. Williams, and we can get it scheduled for a prelim within the next 20 days if that's his wish.
A timely preliminary hearing within 20 days.
Yeah, that's,
Okay.
yeah, that makes sense. Let's get that scheduled right away for you. Good luck.
Okay, next is Antanisha, right?
We're just here about
All right, we'll call the case of the state versus Antanisha Branch, case 26 CM8. Appearances, please.
Cameron Davies for the state of Wisconsin.
Ms. Antanisha Branch is present in court with Attorney Tracy Lencioni.
All right, thank you. You should have a copy of the complaint, Attorney Lencioni.
I do have a copy. We've had an IA on this case?
I don't think so. Let
Okay.
me take a closer look.
Then what I want, okay.
She is in custody, I think, on other matters.
All right.
It looks like maybe a P&D hold.
All right, so I did receive a copy of the criminal complaint, and I believe Ms. Branch has as well. I wanted to point out the last paragraph on page 1 references section 938.34 sub 14T of the Wisconsin statutes. It says that the court shall require that the juvenile participate in 100 hours of supervised work program. So I
Yeah.
don't think that's applicable.
Any response on that point, Attorney Davies?
No.
I think you're right. I think we need to strike that part of the complaint. That is reflected in CCAP with a specific modifier, so I suppose we'll figure out a way to get rid of that. What they didn't include on the CCAP version, maybe they couldn't include both, what was the repeater allegation, so I suppose we should make sure that the electronic record is consistent with the misdemeanor charge, with the repeater allegation, but without that juvenile code section. Good catch. Did you say she does qualify for a public defender?
I didn't mention, but Ms. Branch does qualify.
Okay. In this case, I ought to get assigned to Judge White because of the hold. What's the state's position regarding bail on this?
I would ask for a low amount of cash bail, say $300. That's for the sole non-monetary condition that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription. Might be a bit of a moot point. It does look like the Department of Corrections is proceeding with revocation on the defendant based on my notes. That being said, it looks like part of that is because she was previously given an ATR. So she has not been performing well on supervision. That supervision comes out of 3 years of probation. She got that pleading to a number of crimes back in July of 2024. She was picked up into the jail based on, I guess I'll say, criminal activity. I don't believe it was actually charged by our office. Looks like she also has pending charges out of Jefferson County. I don't believe anything's been filed there, but it is available in my notes. And even with all that behavior, she's sneaking a pretty substantial amount of cocaine into the jail. It's a lot more than we would normally see for personal use. I think all told, some amount of cash bail is appropriate.
Attorney Lencioni.
I'd ask for a signature bond, this being a nonviolent drug possessory offense. I'm not reading the complaint to indicate that there was any sort of accusation that Ms. Branch was distributing the substance that they allegedly found on her. She was questioned by deputies within the jail. She provided a great deal of information when you read the complaint about handing it over, what it was, how she got it in there. I would ask for that signature bond because there is a DOC hold, but as well, she has a very young child who does reside with her when she's out of custody. And by very young, I mean a 3-year-old. Her parents live in the area as well as extended family members and friends. And she does have a Madison address on Milwaukee Street. She pays her rent. Her name is on the lease there, and as I mentioned previously, when the court inquired, she does qualify for public defender representation. So in light of the nonviolent aspect of the accusation, I would ask that we leave it up to the Department of Corrections on whether they're going to release her or in fact proceed with revocation.
Any response from the state?
No, not at this time.
Well, there certainly is a reading of the complaint that makes it serious to the extent that it's alleged to be about 1.5 ounces worth of crack inside of the jail. At the same time, she's charged with misdemeanor possession of cocaine, a straight possessory drug offense. It's not the sort of charge that's likely to itself result in some form of revocation or have there be a substantial additional sentence. I think I'm guided by the charge here, and I'll set a signature bond. I'll not set any specific conditions of bond. I don't generally think of this as me making a bail decision based on deferring to the Department of Corrections, but I suppose as a practical matter, that's what ultimately is happening here because on the merits of a misdemeanor cocaine possession charge under these circumstances, it's probably a signature bond case. Good luck to you, Ms. Branch. Take care.
Sweet. Next is EMILEE COFFIN.
Let's hear about bail.
Okay, we'll call the case of the state versus Emily Coffin, case 26 CM 9. Appearances, please.
Cameron Davies for the state of Wisconsin.
Emily Coffin is present in court with Attorney Tracy Lencioni. This is a special appearance. We have received a copy of the criminal complaint. We waive its formal reading. It does appear that the mailing address listed on the criminal complaint is the proper one. And, right there? Yes. Okay. And Ms. Coffin is eligible for a public defender.
All right, thank you. State of a position regarding bail.
The state is requesting a signature bond. I would ask for non-monetary conditions that the defendant be banned from the American in Monona. That's spelled AMERICINN, and that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription.
Those conditions. No. Okay, no objection.
Anyone have thoughts about weapons conditions?
I'll defer to the court. I don't have reason to make an argument at this time.
Okay, Attorney Lencioni.
No.
I'll order a signature bond. I will admit that's with some reluctance, Ms. Coffin. Some of the behaviors in this complaint are very concerning. And I think the state could have made a credible argument for some cash bail. Well, I will say that the public safety assessment report does also recommend that a signature bond could be appropriate here. So I'm willing to go along with that. I will have as conditions that you not be at the American in the city of Monona. I'll also order that you not go armed with dangerous weapons. I think there's an ample basis for that described on page 3 of the complaint. I'm going to decline to order the drug related condition because it's against the law to the possessor to drugs anyway. So I'm sure that if there was use detected, the state would have tools if it chose to use them to charge you. But that's not me giving you permission to use. Obviously you can't because it's against the law anyway. That's my point. Yeah,
May I ask a question?
sure.
How should I go about trying to obtain my property back from the American?
Yeah, you may want to contact the Monona police and see if they're willing to help you go there and retrieve those things or make some kind of an arrangement. Don't go do it on your own though, because if you go there, they're probably going to call the cops and then you're going to wind up back here.
Okay,
Let's not have that happen.
so you think Monona PD would make sense, right?
I would think so, because that's where this is alleged to have occurred, so they would be most familiar with the situation.
Okay,
Yeah.
thank you.
Good question. Good luck to you.
Thank you.
You're welcome.
Next is Talisha Williams.
All right, we'll call the various cases of the state and county versus Talisha Williams, cases 24 CM 2175, 24 CM 2176, 25 CF 2663, 25 CM 512, 25 CM 1366, 25 CM 2801, and 26 F07. Appearances, please.
Cameron Davies for the state of Wisconsin.
Ms. Kalisha Williams appears in court with Attorney Tracy Lencioni.
Okay, and there's a somewhat complicated series of events here, but in 24 CM 2175, 2176, 512, 1366, and 2801. We're here for bail hearings in response to a pretrial services violation report predicated on the arrest for the behavior that appears to have been charged as a non-criminal ordinance violation in case 26 F07. In case 25 CF 2663, there's that dynamic, but also a served warrant. That warrant was issued after a missed preliminary hearing on December 11th. On the forfeiture, why don't we just order release without bail and get a not guilty plea entered? But we should talk about bail and conditions of bail and the other matters, I suppose. Attorney Davies, maybe you have some proposal for that.
Sure. So what I'm gonna ask for across Miss Williams' open cases is I'll ask for $1,000 in case 25 CF 2663. In the other misdemeanor cases, I will ask for, let's call it $500 in each of them. Terms of support for that, obviously the court outlined sort of the complicated means of getting here for a bail hearing on all of these cases with the pretrial service violations. What's concerning to me is the missed court and the sheer number of cases. The defendant has a significant number of cases open here, and it appears that she has a really, really terrible history of appearance for court looking across the state. I noted, and I won't hold this too much against her as opposed to what else I have in my notes, but I'll note she had one case out in Rock County that I took a look at. It was pending for over 2 years because she had 6 bench warrants in those 2 years. That was just a retail theft. And because of her resistance to coming to court, it just lurked in the ether for 2 years. Here in Dane County, she has 6 open cases, tons of bench warrants over the past few years. I'm going to note 2 bench warrants that were issued February 2nd of 2023. Those weren't served for a little over a month. 2 bench warrants that were issued April 20th of 2023. Those were not served until August 9th of 2023. 2 bench warrants that were issued January 7th of 2025, 2 bench warrants that were issued February 14th of 2025, 3 bench warrants that were issued May 28th of 2025, 4 bench warrants that were issued September 8th of 2025. Those were not served until November 20th of 2025. And then we have the most recent bench warrant that was issued on December 11th. She was only picked up on that bench warrant because of a new referral. I understand that that was not ultimately charged out criminally, but it would weigh against her in the sense that she didn't turn herself in or take accountability in any way. I think ultimately, if we don't want these cases to lurk in the ether for 2 years, while Ms. Williams continues to fail to appear for court, cash bail has to be increased substantially.
All right, thank you. Attorney Lencioni.
Okay, so focusing on just the CM cases that are here for a bail hearing, if the only reason that,
I bet I know what you're gonna say, but I should let you say it. Go ahead.
and you can say, I knew you were gonna say that when I'm done, but if the only reason for putting the CM cases on the calendar for today for a bail bond hearing was the alleged conduct that has now ultimately resulted in the Dane County District Attorney's Office bringing a forfeiture complaint, just point blank, I'm asking that her signature bonds be reinstated in those cases, because with those cases, there aren't any, there was no missed court appearance that led to a bench warrant being issued.
It is what I thought you were gonna say. You said it much better than the way I was thinking it. So, good work.
I mean, how you thought I would say it? I'm
No.
teasing. But that I think would be my strongest argument for just reinstating those signature bonds or keeping those signature bonds in place for Ms. Williams. And it was not that long ago where her bail was converted to a signature bond. I think it was toward the end of November when a commissioner, not yourself, decided that signature bonds were appropriate with pretrial services. As far as the felony case number, and the missed court date on in December, Ms. Williams represents to me that it does look like it was set early in the morning. I think it was set at 8:30 or so. Ms. Williams said that she did go to the courthouse, but by the time she had arrived there, she had been informed that they had already handled the matter and learned that it had been issued with a warrant. But she also had a signature bond in that case, despite the number of pending cases that Ms. Williams had. She is eligible for a public defender. In many of these cases, the CM cases, she has court next Thursday. So it's coming up pretty quickly for a pretrial conference in those cases. There's not a doubt in my mind she's going to be given notice of those court dates coming up. And then there would be just the matter of rescheduling a preliminary hearing in the CF case. So I am advocating for signature bonds across the board, despite the missed court date, but it was that she was late, as she stated. And I'll just shut up now.
No need.
No, I was just gonna start making a circular argument, so I figure that's my time to stop.
Okay, fair enough. Any response from the state?
Sure. I'll just briefly note that, you know, I have no reason to not believe that she showed up late, other than the fact that there's a bunch of ways that she could have resolved that bench warrant between December 11th and December 29th when she was arrested, that she did not solve them. I would also note that the oldest case we're here to address today is coming up on 1.5 years old. She continues to pick up new cases. And while I understand and quite frankly, I also saw where Attorney Lencioni was going with her point. I think it's a fair point. I would just note that, you know, something has changed between the last time we addressed bail and those other open cases and us addressing them. Now, while it's not necessarily a new arrest, while it's not necessarily a pretrial services violation that I think raises a ton of concern, we are still here because between the time that that signature bond was set and now, she has missed a mandatory court appearance. So I'll stand on my argument.
May I just mention one last thing? I do notice that in the pending CF case where there was a, you know, we'll just say a late attendance or a late arrival to the scheduled preliminary hearing, she at that time was unrepresented. She is represented in the misdemeanor cases, but I don't see that there's been an attorney assigned, or at least had not had an attorney assigned by the December 11th preliminary hearing, so.
So I have looked through the court record in most, if not all, of these pending cases. There are some kind of unusual aspects to this. One of them is the number of pending cases Ms. Williams has now that with signature bonds. That's not the ordinary course of things, though I think Attorney Lencioni explained that perhaps in some of those cases there was changes to signature bonds post initial appearance, and that's fine. The other odd part of this is that when she failed to appear for the prelim on December 11th, shortly after that, pretrial services produced an informational report, as it was termed, saying that they were just no longer going to monitor any of the cases that she's in pretrial services for because of the outstanding warrant. That means effectively she's been unmonitored since the middle of December. It suggests that continued use of pretrial services in this case probably isn't much more likely to result in positive results. It didn't assure her appearance in court. It didn't assure timely resolution of the failure to appear in court, and it didn't prevent the new arrest on the new matter that ultimately was charged as a county ordinance violation. I think with failing to show up at a court date and getting arrested, at least at a level of probable cause on new charges, there would be an adequate legal basis for us to adjust bail in all of the cases. I tend to agree with Attorney Lencioni's analysis, though, that that's not the right answer for me to engage in. And I'm doing that because a decision was made that the new conduct was not criminal in nature, at least in the opinion of the office that gets to make that decision. And for those reasons, I'm going to only adjust bail in the various misdemeanor cases so that there's no longer required participation in pretrial services. The prior bail regime will otherwise remain in effect in those cases. In 25 CF 2663, that's the case with, in addition, the missed court date and the not taking care of it. I think there has to be some adjustment to the bail. I recognize that the net result of this is going to be something that I really avoid doing, and frankly, I'm critical of when recommendations are made like this. But this is a unique procedural history, and I say that just because there's going to be inconsistent bail results. She's going to get cash bail on one of these cases and be allowed to remain out on signature bonds on the other. Again, I think this is an unusual fact situation. The felony case is more serious. It's a felony case. It's alleged to have occurred while on oodles of bail. There's an allegation of of some form of resisting or obstructing in that case. I should look to see what the detail of that is. I was use of another person's name allegedly. I'm gonna grant the state's request on that charge, so I'll set $1,000 cash bail in the felony case. We're not gonna increase any bails on the misdemeanor cases. And in that case, I'll also continue the previously imposed conditions except the pretrial services participation. I think that puts us in the same position we likely would have been in if we were just reviewing the warrant return based on the missed court appearance without making a bunch of adjustments for the new arrest that didn't amount to any criminal charge. Good. We should
Wait.
talk about timing of the prelim. I assume she wants us to get that put on right away.
If we could get that put on right away, and then I think we also need to address the FO matter.
Oh, I kind of did it
Did you
in
just-
passing at the beginning, but my intention on the FO matter is to enter a not guilty plea and have her released without
Okay.
bail on it.
Sorry.
Yeah,
I
she doesn't
missed
have to
that part.
post anything on that. And that'll allow for that case to get us set up for a new court date at the same time as some of the others. Good luck to you, Ms. Williams.
Okay, this way. Next is Dolores Parker for a forfeiture.
I think you might be done, Tracy.
Yellow lights.
Okay, let's call the case of Dane County versus Dolores Parker. It's case 26F05. Appearances, please.
Cameron Davies for the people of Dane County. The defendant appears in person in custody without counsel.
You're Ms. Parker, right?
Yes, sir.
Okay, some good news for you. It looks like the DA's office decided not to charge you with any criminal offenses.
Okay.
They did charge you with a county ordinance violation, like a ticket. In this case for possession of paraphernalia.
Okay.
You could enter a not guilty plea to that. If you do that, we're gonna release you from jail today. You won't have to pay a bail. You just have other court dates and it would keep open your right to even have a trial on that charge at some point.
I'm just gonna plead guilty to it.
All right, well, let's see if and that's fine too, but let's see if the county has some sort of a proposal for how to resolve that.
The county would resolve for court costs.
Okay, well, that's about as low as it could possibly get, but it's $114.50. We get you some time to get it paid. You're still getting out today.
Okay.
Does that work for you?
That works for me.
Okay, I'll accept the guilty plea. I'll find you guilty. We'll just impose the court costs.
I'm on disability, so how much time do I have to pay this?
Yeah, so I can give you 60 days. If you need more time, talk with the clerk of court's office about it. They'll work with you.
Okay, 60 days?
You got it.
I can get it done in 60 days.
That's even better. All right, take care, ma'am.
All right, thank you.
You're welcome.
That's everyone.
Oh.